My lord, on indulgence, the state appeal, e-filing is completed, but wrongly my clerk, a, page 9 in the order sheet, original order sheet. That's why
Pardon?
e-filing is completed, but when I go into the filing section, they are objecting that you have to take leave from my lord. The original order sheet, my clerk already by mistake page 9 there. That's why they are not taking.
Paginated it.
Page 9 in original order sheet. WPST matter.
So, what in the original copy you have put the numbers?
Already annex.
Running page numbers have been put also on the original certified copy.
That
Therefore,
you cannot
department is
do.
not taking the filing.
Yes, my lord.
Perhaps seeks leave so that he can file in this way or something.
That way you cannot file, sir. It will create a
My lord,
precedent.
but it is a mistake by done by my clerk.
Obtain a next copy and give it. You will get it within a day. This will be creating precedents. Please obtain a copy and file it. It is no such urgency.
No, they are not taking the, if I taken out the original order sheet.
No, you will substitute that with the original copy. Finished. Yes, what you are saying.
My lord, item number 3 of my lord's list, my lord.
Why you are mentioning?
I am led by Mr. Shoktinath Mukherjee, my lord. He has not been keeping well. A humble prayer, my lord, on his behalf, my lord. If I can make, my lord, I put the other side on notice also. Mr. Siddiqui is there. If it so commends to your lordship, my lord, will it be your lordship's pleasure to take up this matter? If it commends to your lordship, my lord, on the 20th of this month, my lord.
We keep it on the reopening date, you come and 22nd of January. 2nd January, Mr. Yes, next.
2nd January. Obliged.
2nd is not a holiday.
I hope it is not a holiday.
Keep it on 3rd.
3rd.
Let us be safe.
3rd. I hope 2nd is not a holiday.
You should hope that it is a holiday. Yes. That will be better for you. This is what we did. We didn't put the date yesterday. Just I have added that.
Item number 3 on 3rd, my lord.
My lord.
Why you are mentioning Mr. Naik? We are on Tuesday only.
Item 6, lordship. This matter, my lord was pleased to take up the matter on my lord 6th of 12. And direction was that the matter will appear today. But it is totally, my lord, misquoted, misprinted because the name is different. Name is different and so, my lord, an order needs. Of the matter better, my lord, any other day because the file name
will come tomorrow along with the new number and date. New number and the name properly inserted. Who is your other
side? Item number 6, I am for the respondent, my lord.
Yes.
That is Bharat Sanchar Nigam Limited versus Gautam Ghosh.
Yes, there has been a mistake. The name has. It will appear with the correct number and name tomorrow.
All.
My lord, day after, Thursday.
Day after.
Thursday, lord.
All right, day after.
All.
Yes.
Grateful.
Lordship, may I be permitted to mention?
Yes, sir. Monday and Thursday.
This is an appeal, my lord.
Come and tell us on Thursday. Yes.
Well, just listing of the matter, my lord.
The lordship in
appeal filed against the order of Justice Bhattacharya on passed on 19th September 2023. I'm praying for the.
What is the urgency? Come and mention on Thursday.
Yeah.
Yes.
Your Lordship, in item number 1, I appear for the appellant petitioner, Your Lordship. This has come up at my instance. I had mentioned this matter before Your Lordships yesterday, indicating that this is a Group 6 appeal relating to the year of 2021, Your Lordship. And Lordship, subject to...
We don't have the determination.
Your Lordship, subject to correction, Your Lordships perhaps do not have the determination. It commences from 2022 onwards, Your Lordship, as per the list.
This court does not have the determination to hear this matter. It is an appeal of
2021, Your Lordships.
Here, and as such, the same stands released from our list.
I'm for the respondent, my lord.
এই ওনার নামটা ফেলবে বোল্ড
শ্যামল
লেটার
চক্রবর্তী।
মিস্টার চক্রবর্তী হ্যাঁ
Date of on behalf of the respondent.
My lord, I am for the petitioner, my lord. My lord, this application arises out of non-payment of interest by the tribunal and non-payment of gratuity by the respondent despite of the order of the tribunal.
who has preferred this writ petition? You have preferred.
I have preferred this application
For what?
for interest. I paid before the tribunal for the payment of interest, delayed payment of my retirement benefit. That part has not been allowed by the tribunal.
Mr. Mukherjee,
My lord.
you comply this order. We will consider the question of interest thereafter.
Yes.
But your authorities may take a stand that since the writ petition has filed, we will not do
No, no,
anything.
my lord.
Let it proceed.
Proceeds on the basis of the order passed for the learned tribunal.
No, but we will consider the question of interest thereafter. Otherwise, he is a double loser. He neither gets his benefit nor does he get interest.
When so far as the directions of the tribunal, that would be, we will take steps as early as possible. Kindly see the order passed for the learned tribunal.
My lord, I have some prayer, my lord. In terms of the tribunal order, other payments has been made,
Oh,
But-
payment made.
but gratuity has not been paid. And the interest.
Is your pension payment order? Have they issued you the pension payment order?
Pension payment order issue করেছে?
পেনশন দিয়েছে
Yes, yes,
পেনশন দিচ্ছে
yes.
পেনশন দিচ্ছে
So pension payment order would mention the amount of gratuity.
Yeah.
Where is the pension payment order?
PPAtor.
Mr. Mukherjee, do one thing.
Hmm.
Take instruction whether the gratuity is being processed or not, because that is the direction.
Yes.
And come and tell us that when you will be disbursing the gratuity in terms of this order. Thereafter, we will decide Mr. Chatterjee's point of interest.
Point of
Finish.
interest,
You
hmm.
get that?
Lordship.
So when do you, prior to the vacation, give him some benefit?
Yes. Give me one more.
You are sure, Mr. Chatterjee, you have not been given gratuity
I have not been given gratuity, other payments has been made,
except gratuity?
except gratuity. And the tribunal has not, although I have made a prayer before the tribunal for payment of interest.
See, understand that. Let us see how they work out the gratuity. You get the benefit first.
Lordship.
Acha, heard Mr. Chatterjee, learned advocate appearing for the petitioner.
20th.
Mr. Mukherjee, learned AGP appearing for the state is directed to avail necessary instruction, establish the matter for further consideration in the daily supplementary list of this court on 20th December.
20.
Let him come with that instruction, then
Lordship.
উপরে affidavit of service filed by the petitioner be kept on record.
Service টা দিয়ে দিয়েছিস?
দিয়ে দিয়েছে
Mr. Mukherjee,
Well.
apply your good office, pay the gratuity.
I shall try my level best.
You have no gratuity.
We have no gratuity, no pension. They will debit the office, nothing.
Nothing. You should take up this.
Except 330.
চলো next.
Give your lordship.
জয়ন্ত কি আসছে না নাকি?
Oh, my lord, I am for the petitioner, my lord. My lord, I appear for the state respondent.
Yes, what is the matter?
My lord, an application, my lord, was made, my lord, to the BLLR of Pandua my lord, for correction of the record of rights, my lord. Since, my lord, what are you doing? For the four data.
হ্যাঁ 4 মোহন পান
লিস্টে আছে 128
প্রদীপ চন্দ্র
My lord, Pradeep Chandra. My lord, I am making a mistake, my lord. I tender my apology.
এখানে আছে আল্লাহ তুমি রিড নাম্বার এটা আছে
Oh, the rate number which I have served is 128 of 2023. Well, I tender. I'm not appearing.
so you can appear also, no problem.
Mr. Gandhi.
He is junior to you.
No, no, we are in the same footing. My lord. We both are AGP.
Oh, I see, I see.
And he's my very good friend, my colleague also.
Yes.
My lord, an application was made, my lord, to the,
How you are agreed by this order?
my lord, fixed 1 year later.
Hey, dey.
My lord, I'll just indicate, my lord, the difficulty. My lord,
Now this was a division bench.
this was, my lord, a division bench.
Now there is a single bench. No second member.
This is, my lord, a land reforms tribunal.
There are two. There
Here, my
are
lord, is, my lord. This is not, my lord,
newly appointed.
newly appointed, my lord. This is, my lord, land reforms tribunal is, my lord, functioning unlike, my lord, the administrative tribunal, my lord.
What was your prayer before the tribunal?
My lord, I'll just indicate, my lord. An application was made to the, my lord, learned BLLRO, my lord, of Pandua in 2019. My lord, he did not consider my application, my lord, for correction of record of rights. Since, my lord, my claim was that the land was not vested, and, my lord, there was, my lord, for correction of record of rights. Now, my lord, it was not considered initially. Therefore, my lord, an application was, my lord, filed before the learned tribunal in 2022. And, my lord, an order was passed by the learned tribunal to consider my representation within a period of 6 months. The lordship will find it, my lord, at page 79.
Then what happened?
After that, my lord, I communicated it.
That order was passed in the same original application. No.
My lord, no, it's the previous application. Previous
Now
application,
you want implementation of that.
implementation of that order.
This is a second round of litigation, thereby the date has been fixed, calling for that report.
You call it. You call it.
Malad,
Simple matter. Why
yes, that I understand. Malad,
Mr. Ganguly, you contact the BLRO and you call for, because the order was to consider and pass an order.
an order, report only.
No,
No,
the
no, previous,
earlier
79.
original.
Earlier one, yes.
It's an extension. What was it? Page 79.
79.
Having did the direction upon BLRO to for hearing and disposal.
Yes.
So if he has not done so, ask him to do so.
Within a limited period of time.
Uh,
Malad, let me take instruction to that effect, Malad, or if your lordship may direct, Malad, will
Why should we take away the jurisdiction of tribe?
Malad, then in that occasion, Malad, let it
We
be.
ask you to. We have told you. You ask the BLRO to call him, and if he has already heard thereafter, let him
Nothing
pass
like
the
that,
order,
the report
nothing
will be-
remains. And if he has not heard,
Malad.
then he can hear and
Yes.
dispose. So when do I keep? We keep it.
End of this month, করো না? January করো না।
Problem is that we cannot honor these persons because we feel embarrassed. We had also our hybrid করে যাচ্ছে. What is this? I mean, a date given for what? Just come.
Before vacation, but in the meantime, we'll be with the entirety of the.
Where you called for a hearing.
No, nothing. No steps have been taken, my lord. I have got, my lord, that is my averment in my, my lord, fresh original application for implementation of that order, my lord.
What is this, Mr. Ganguly? Twice he has to approach to authority to discharge their statutory.
No, I've seen Malad after that
Tribunal
immediately.
fixes a date 1 year later.
Malad.
Mr.
Well-
Ganguly, do one thing. If he has not heard, you tell the BLRO to fix a date.
Yes.
We will ask him to go and attend the BLRO office.
Right.
And the BLRO will pass an order. Will pass an order and communicate the same within a particular period, and we dispose of the original application itself.
Grateful.
Yes.
Grateful.
Malad.
When can you come tell us? You come with this instruction. Which date he will be hearing him? Finished.
Well, in the meantime, the exercise may be done, my lord, if your lordship keep us next date after a couple of weeks, my lord, I'll think in the meantime, the exercise can be done. They may give a notice and they may immediately ask them up and make the hearing. And
May not happen, Mr. Ganguly. He might have some other reasons that some other BLRO has passed. We do not know the
well,
fact.
then,
Please take the instruction to this effect and come and tell us in
my
the
lord,
next
my lord, my lord, my lord.
evidence or service. ওই same order করে দেবে। It's
Well,
kept for-
next week, my lord.
When do you want it? Tell us.
Next week, my lord.
Yes, next week we are keeping
Any that should your lordship, my lord.
Mr. Ganguly learned is directed to take necessary instruction. Is the matter for further consideration. Daily supplementary list of this court on 20th.
My lord.
Grateful, grateful.
Please, Mr. Ganguly, come.
My lord, we have already intimated them. Actually, I received it yesterday only. Immediately we informed them.
No, you ask him what can be the date of hearing.
Yes, yes.
We will ask him to go and
With a
attend.
proper proposal so that they may.
Grateful. my lord.
Grateful.
20 তারিখ রেখে দিই, হ্যাঁ? Evidence or service কে।
I am for that. My lord.
5 ওই যেটা ভুল হয়েছিল। What is this matter?
এই হচ্ছে কমা। হ্যাঁ, সেট করেছে। এখানে আর কিছু করার নেই, পার্থর নাম দিতে হবে। পার্থ চক্রবর্তী। কালকে শরীর খারাপ, ফোন করে বললো কি করার নেই। এই বইটা কোথায় বইটা? পার্থ চক্রবর্তী।
Yes, what is the matter?
Well, I am for that. Copy has been served as per order of the
You are
on
appearing.
30th.
You are
I'm
appearing.
appearing.
You have got instruction.
Respondent, no, my lord, I didn't get any instruction. My lord, my lord kindly comes to my lord, since there is no scope for interim order, my lord, that even, my lord, kindly allow me to file affidavit in opposition, my lord. Because, my lord, he was in service for 4 years, my lord, which has been reflected in the order of the tribunal, my lord. My lord, kindly comes to the, my lord, the impugned order, my lord.
Now you have only, you are saying that according to you, only 1,000, 2,000 rupees is available as
I'm
well.
not of that, my lord. My lord, since he was in service, my lord, for 4 years, my lord, according to the pension rules, she's not entitled because
No,
her husband
he
was in
a
service.
labored in 1971. He died in 83.
No, my lord, he was
he entered as
prior
casual
to
labor,
that he was a general laborer,
casual labor.
casual. His post was permanent in the post of gangman in the year of 79, and he was in service for up to 83, my lord.
And before that, he was casual.
Casual.
My lord.
He was died.
So that casual working cannot be added as qualifying.
Well, that
service.
is the pension rules, my lord. Well, I've gone through the pension rules, my lord. But that is why, my lord, I am praying before your lordship so that I can file my affidavit in opposition. My
Now
lord.
the tribunal did not call for affidavits. Did
My
you
lord,
fi-
because
did they
my
file-
lord,
That
applicant
was
applicant
actual
had not
decided
appeared.
expertise. That
Because-
was decided
No,
expertise.
my lord, there was a
The
notice.
advocate for the applicant
Hmm.
did not appear and did not go
Oh.
to the case. And that was actually past order expertise.
So your contention is that his service is to be calculated from 79.
Not only that, my calculation is that he was entered in the service 71. Thereafter, he was declared on the post as a decasualized and appointed in the post of gangman in the year 1979.
Very good.
But in the case, and he died, unfortunately died in the year 1983.
Very good.
Really rules is very clear that if he dies after the second day of his appointment, he is entitled for pension.
Show us. Have you annexed that?
Yeah, annex, sir. I have given the, I've given the annex, sir. My lord, you please see. 46.
Page 46.
46.
Hmm.
Para 18.
Where is that?
A temporary servant which has or supervision or on being declared public service further railway service by the appropriate medical authority after having been rendered temporary service for not less than 10 years shall be eligible for under supervision.
That is for retirement on superannuation.
In the event of death of 3 number.
Yes, of a
In the
temporary.
event of death in harness of a temporary railway servant, his family shall be eligible to family pension.
Hmm.
That and death gratuity of the same scale as admissible to families of permanent railway servant under these rules.
Then where is this railway circular 4686? On the basis of which they have calculated?
Actually, where
is the letter of 30th November 1999?
I am going to pension, my lord. This is pension is very clear.
Such was the reason they have passed an order on 30th November 99. Have you got a Xerox copy has been annexed?
Yeah.
Huh?
Just
Where? 30th of November 1999. Where do you have annexed? Page 32. Page 32. Page 32. Your reference remarks non-payment of settlement dues in terms of CPO serial such and such. Where is this CPO serial number 46? You don't have.
I don't have. They are telling. Pension is telling. I don't have any circular like that because really compensation rule is very clear. Pension rule is very clear.
Where is your appointment as gangman?
Yeah. That is, my lord, if page 42.
Page 42.
Release documents.
42 is what?
It's an appeal.
Shamapada Chatterjee, father name Subodh Chandra Chatterjee, designation decasual, date of appointment 23/4/79 as a DC gangman, date of initial engagement as casual labor 1/1/7/71, date of birth 5388, PF number such and such, PF number started from 1580, scale of pay 2000 to 2550, 200 to 250. Date of death 2383, die in harness on the very date of death.
No, you were previously a casual gangman.
Casual gangman in the year entered in the 1971.
Subodh designation. What is this designation?
Decasual gangman, DC gangman, decasualized gangman. Decasualized money. On that time he was not casualized, he was decasualized. Money he was actually having the temporary regular service. That is called decasualized gangman.
The appointment letter. But there's not the appointment letter. These are only the particulars of the
daily worker.
Date of initial
Sir, if you
engagement
see,
is
this is
This
not,
is his particulars of service.
these are only the particulars of the service, but there's not the appointment letter. If you see the subject on the top, it says an appeal for issue certified.
Actually, he has died. Actually, he has died in the year 1983. At this present date, it is not possible on my practical position to give the appointment letter. On that time, casual labor appointed on line system. Sometimes standing on the line and he has entered casual labor. After 4 years, 1979, after 8 years of casual labor, he was declared in the year 1979. And family pension rules is very clear.
Applicability and the next page, sir. 41. After clause.
But what does this say 40? That's referring to. Page he refers to it, sir.
Let me record the page.
18,
46.
Family pension rules also দেখো,
Railway expedition.
is after 1 year service.
So the present writ petition. This has to be on affidavits. They have to come with
Actually,
an affidavit.
Judgment is clear, judgment is here. I can show this
But
judgment
not on
as
that.
passed by the tribunal.
So they have rejected your case on the basis of a CPO serial number such and such.
If the CPC rule is above the
Let them come with that. How will you adjudicate? Unnecessarily you are making submission. Or can you come with the instruction and shorten it out? We can decide the matter. Because of old lady, she will not be getting her pension. Huh?
My lord.
Then when can you come with the instruction? Tell us.
Next week, my lord.
next week.
But you have to produce the circular, na?
My lord, I understand, my lord. The circular upon which the pension Adalat has issued the order.
Pension adalat, yes.
Yes.
You file a short affidavit, we are fixing it on a particular date and finish it up. The present writ petition has been preferred.
Yes,
That has to
yes,
come
yes.
with it. The present writ petition has been preferred, challenging an order dated. What is the date of?
This is
You have not challenged the order also. How do you file writ petitions? I don't understand. You have not challenged the order also. See your prayer.
The challenge not.
How do you draft petitions? I don't understand.
Mhm.
26th February 2004. This is a 2004 order. Tribunal order is of 2004.
2004.
you're coming now?
You're coming now.
Actually, that lady sitting in very remotest village, she has got no knowledge of this order at least.
So you are coming after 20 years.
Pension is the constitutional right. It is not actually.
Oh, you realize that now when he visited your place, you realized.
My lord,
No,
that apart,
actually-
my lord.
Actually, they.
What you have said about the delay, tell us. Where do you have a pensioner, even if fundamental right, delay will not stand in the way? Where is your ground? We all make extempore speeches without determining that we should file a proper application with proper explanation. Have you written a single line in your petition that pension is my fundamental right, so I can sleep for 20 years and come to the court? Have you written anything in your application?
Well, that apart, my lord, he died in the year of 1983, and my lord, representation was made in the year of 1998, my lord. And my lord, in spite of notice, my lord, I understand, my lord, my lord, but in spite of, my lord, several notice issued by the learned, she did not choose to appear, my lord, even in the cat, my lord.
And that was also dismissed without any your absence.
My lord,
That was
even
expertly dismissed.
my lord, kindly comes to the
Expert,
first page,
expertly
my lord.
ordered. That was expertly ordered. The
My lord, kindly
AD
comes to the
have
my lord,
got
the
no knowledge of
first
this
line
order.
of the impugned order, my lord.
What
on-
you are saying? What you are
AD
saying?
has not got of no knowledge of this order because I
And you got the knowledge on 98 then? You went to the pension adalat.
actually applied for certified copy, and after getting the certificate I came to
2004 order you applied in 2022.
I got the certificate.
Certified copy.
Certificate copy applied, and that was
Why don't you make proper amendments in the application? Mr. Please ascertain whether this lady can be helped or not.
if
If anything can be given, please decide, come and tell us.
My lord, I just
actually certificate copy has withdrawn on 23.
Hard Mr. Such and such learned advocate.
20.
Hard Mr. Learned advocate appearing for the petitioner. So Mr. Learned advocate appearing for
Devashish Basu, for the respondents.
Subhash learned advocate appearing for the respondents is directed to avail necessary instruction. List the matter in the daily supplementary list of this court on 9th January. Affidavit of service filed by the petitioner be kept on
My
record.
lord, on 3
Forget
consecutive.
about the delay. Please ascertain from your officers whether anything can be done or
My lord,
not.
I understand, my lord, whatever has fallen for your lordship, my lord, but in 3 consecutive
Actually,
days, my lord,
my
notice
lord,
were given to the.
Same judgment in the matter, and they have complied with same judgment. Regarding the same matter.
So where have you stated in your petition?
No, that I have got.
Is it not your duty, sir, to do a draft a petition upon availing necessary instruction and properly draft it so that I can explain the delay?
Actually, I have got and explain the delay.
This way, please do not. This calls for more suffering of the client. You are asking a client, she has moved on your advice. She is a illiterate lady, what she will learn? She has moved at your advice. Is it not your duty to tell her that we have to explain the delay? One fine morning, people guys, he will take the point of limitation. Please be more, your junior should draft the petition in the appropriate manner. So next one. Please, Mr. Vasu, please see that.
No, 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 I will.
And take it. That is why we didn't write the order with that date.
Your lordship, within your lordship.
আবার কি ভয় দেখাচ্ছে? কি বলছো?
My lord, your lordship, kindly have a look to page 43 of this. Bharat.
Seen it? You have got to.
Bharat,
Show him
acha.
page 43.
Page
43.
My lord. But the guideline for review medical examination.
Page.
My lord, at the bottom, my lord, the pagination is there, my lord. Got it, my lord.
Guidelines. Yes.
My lord,
What you are showing,
my
Mr.
lord, in second paragraph,
There should be taken.
your lordship will find the review during review medical examination, selected candidates are rejected
When you are reading, Mr. Rai,
Malad, towards middle of that paragraph. Your Lordship got it?
Second paragraph.
Second paragraph.
yes,
1, 2, 3, 4, 5, 6th line. 6th line, Malad.
during review,
Madam.
yes.
Medical examination selected candidates are rejected on medical physical grounds only on clinical findings which are not substantiated by valid expert opinion investigation report. Inconclusive rejection of candidates only on clinical findings which may differ from one doctor to another usually leads to embarrassing situation, particularly before the honorable courts, because judiciary, for the sake of protecting natural justice, heavily rely on investigation report and specialists, super specialist opinion. But here, I'm not on that, heavily on that, but here when the review result was given to me, but there was only indication that my candidature is not acceptable because of that the psychiatric problem. So far as the supporting medical experts report has not been formed part of the decision.
But the medical board itself is of doctors. Review medical board is of the doctors.
Your
Not of any independent.
Your Lordship, kindly see this, for the sake of protecting the natural justice, heavily rely on the investigation report, specialist, super specialist's opinion.
Now kindly come to page 30.
My lord, I got it, my lord. My lord, only, my lord, this, where from they concluded this, my lord, that has not been spelled out. But now I'm coming, my lord, next part of this, my lord, the guideline. Board condition for review medical examination. But here, my lord, another avenue has been given to the candidates. But why I'm on, my lord, when this observation was given in the review board, my lord, immediately thereafter, I approached the district medical authorities, and my lord, before, my lord, the decision of this honorable court, the district medical authorities started investigation regarding myself. And they came with the final conclusion on 19th. But 18th, my writ application was rejected. But these particular, the report was not taken into consideration because the affidavits were not called for. But this is one aspect of the matter. But the second aspect, this part, your Lordship kindly see, only one thing, your Lordship kindly visualize. But the boy or a candidate which was before the medical board can make out a cock and bull story and explain his injury. But he, the one aspect your Lordship kindly consider, that so far as which is lacking nowadays in ourselves, that the honesty. But he has explained why these injuries were there. But only I am harping his case only on that he has the guards to proceed or place his case honestly before the authority, because he can have taken any shelter of any one of the guys and all these things, but he has not done so. That's why I am harping this point before your Lordship again and again. But the next part of this the decision, the guideline, so far as they have stated,
So
after
what is more important? The security of the nation or his honesty?
Both are important, because the honesty has gone from ourselves. But your Lordship has seen, but this is very few cases your Lordship find that the honesty is there in the public at large. Even if myself, I cannot candidly submit before your Lordship. We are losing day by day. But this, I salute to this boy, because he has honestly explained his one of the deed which has done this. Your Lordship, next part, your Lordship kindly have a look. After completion of review medical board proceedings, the final outcome in the consolidated form will be displayed in the information to the candidates on daily basis.
ordinarily, there is no right to appeal against the findings of the recruiting medical officer or initial medical board. But if the government are satisfied on the evidence placed before them by the candidate concerned of the possibility of any error of judgment in the decision of the recruiting medical officer or initial medical board, it will be open to them to allow re-examination by the review medical board. If any medical certificate is produced by a candidate as a piece of evidence about the possibility of an error of judgment in the decision of initial medical board recruiting medical officer who had examined him in the first instance, the candidate will not be taken into consideration unless it contains a note by the medical practitioner concerned, who should be a medical officer concerned, specially from the district hospital and above, along with the registration number given by the MCI State Medical Councils of to the effect that it has been given in full knowledge of the fact that the candidate has already been rejected as under for service by a medical board of the recruiting office, medical officer. Then the appeal should be examined thoroughly and a decision as to the appeal is to be admitted or not is taken at the level of the joint secretary or equivalent of the administrative ministry department concerned. But here,
There is no error in the decision-making process. That is the procedure followed. These guidelines, you are saying these guidelines have not been violated. Your only contention was that the court ought to have granted an adjournment to me to place the next.
this
is your contention.
all that I can
So
submit.
that is why we are hearing you on the veracity of the subsequent medical report. On the basis of that, we do not find any difference with that of the medical board.
Subsequent medical report has, my lord, your lordship kindly see, it has different categories. And all the categories.
What did you challenge in the writ petition, Mr. Roy? Writ petition copy is with you. Did you challenge the review medical board order?
Yes, ma'am.
Yes, Mr. Dalal, what do you have to say?
At the time of hearing in the writ petition before Justice Banerjee, that report has not been produced. Thereafter, it has
Yes.
comes out.
Order. Yes, Ashok, the present appeal. The present appeal has been preferred, challenging an order dated 18th of September 2023, passed by the learned single judge in the writ petition being WPA 20103 of 2023. Stop. Shorn of unnecessary details, the facts are that the petitioner, that the appellant participated in the selection post for partition selection process for appointment to the post of constable bracketed G stop D in the Central Armed Police Forces. Bracketed in short CRPF. He succeeded in the written test and faced the succeeded in the written test and was called for a medical examination. Stop. The called for a medical examination in which he was found in which it was inter alia observed that
one thing, your lordship, kindly have a look on the clause 10 of the guideline, my lord. Your lordship, kindly see at page 39. Page 39, my lord. Investigations, my lord, your lordship has seen. Page 39. What are the investigations required to be taken? Your Lordship has seen
Yes.
3 type: hematology, urine examination, and chest X-ray. So far as these, the branch, nothing has been spelled out, whether it is there is any defect to that effect.
Hmm.
And these particular observations for which I was refused has also not been, comes within the purview of these investigations.
Ashok, participating for appointment to the post of such and such বলেছো তারপর কি বলেছো না he passed the written in short CRPF.
He succeeded in the written test.
He succeeded in the written test, physical standard test and physical efficiency test, and was thereafter called for a medical examination. Stop. On 25th July 2023, such medical test was held, and due to some cut marks on his left hand, he was referred for a further examination before the review medical board on 31st July 2023. Upon examination, stop review medical board declared him unfit on 31st July 2023. Declared him unfit. Aggrieved by such decision, the appellant preferred a writ petition. In which the order preferred a writ petition, which was dismissed by the order dated 18 September 2023. Stop. Mr. Roy, learned advocate appearing for appellant submits that after the review medical board review medical board report, the appellant examined himself before the psychological department, West Bengal State University, and on 8th of September 2023, a medical report was sent to the Barasat Government College and Hospital, and as a final report was awaited, the appellant prayed for an adjournment. However, such prayer was refused. Subsequently, on 19 September 2023, the appellant obtained the medical report from the concerned medical college, and the perusal of the same would reveal that it does not agree with the opinion of the review medical board. And in such circumstances, a further medical examination should be conducted by an independent body. In support of his arguments, Mr. Roy has placed reliance upon the guidelines for review medical examination. In support, next part. Mr. Roy further submits that the review medical examination was not conducted in consonance with the guidelines towards such examination. Stop. Though such argument was advanced The learned single judge did not return any finding on the same, and such infirmity warrants interference of this court. Mr. Dalal and the advocate appearing for this respondents denies and disputes the contention of the appellant and submits that a perusal of the review medical board examination as well as the report dated 19 September 2023 upon which reliance has been placed. Reliance has been placed, comma, the fact that the petitioner is suffering from
But nowhere it is stated,
psychiatric.
but nowhere it is stated that he is still suffering, my lord. Your lordship kindly consider.
কি লিখলেন?
That a perusal of the review medical board examination as well as the report dated 19 September 2000 upon which reliance has been placed,
By upon
declares that Kenar is suffering from
psychiatric problems cannot be ruled out, and as such his examination in the force cannot be considered. In reply, Mr. Roy Learned Advocate, however, submits that there is no specific finding in the reports that the appellant is suffering from psychiatric problems.
Not suffering.
More so when an assistant professor, psychiatrist in Barasat Medical College and Hospital has opined that the appellant is clinically, psychologically fit at present. Clinically, psychologically fit, quote unquote. Hardly learned advocates appearing for the respective parties and considered the materials on record. In the first examination held, in the first medical examination, it was observed that there were, this is hesitation.
Oh,
Cut marks.
and hesitation cut marks.
Hesitation.
Cut marks. Page 29.
Quote
Page
unquote
29.
দেবে, hesitation cut marks left
Left
hand.
hand.
LT HN
Psychiatric.
29 এ আছে। Stop. In the review medical board, such cut marks were noted, and it was opined that the appellant was having a tendency of deliberate self-harm, and as such he was quote unquote unfit. Stop. Next paragraph. As the subsequent stop. The appellant was thereafter examined by the West Bengal State University, Department of Psychology, and in the psychological report and before the department, before the authorities, the appellant himself stated that quote unquote due to stated that he was impulsive and had decided to cut his hand with a blade and has decided to cut his hand with a blade. Stop. the
এইটা না বললে
the medical stop. The report dated, the medical report, the Barasat Government Hospital medical report dated 19th September 2023 also states that the petitioner is having compulsive traits in his personality. Stop. A composite stop. It is not a case that different authorities are have furnished diametrically opposite, does not finding that the different authorities has submitted diametrically different medical reports. All the reports taken together, taking all the reports together, it cannot be ruled out that the petitioner is having psychiatric problems. So, and in view thereof, the learned single judge refused to and considering the fact that he was seeking appointment in the force, comma, the learned single judge refused to exercise discretion in his favor. Stop. Refused to exercise discretion in his favor, and we do not find any patent error of law in such decision.
But one thing, my lord.
Accordingly, the writ petition.
My lord,
the
one,
appeal and
my lord, one thing, your lordship kindly peruse, my lord. Only one thing, my lord.
Yes, Mr.
My lord, page 43, second paragraph, second line, my lord. Your lordship once, my lord. It is not proper on my part.
No, no, no.
Though
no.
I, my lord,
Page 43.
man, page 43, second paragraph, second line.
Second. The order of the court.
No, my lord, that my
Guideline.
compilation. Yes, yes. Guideline.
43. Yes.
Yes, what are you pointing at?
My lord, every candidate must be medically fit to carry out very sensitive and tough duties of the force. This is the requirement. My lord, here, these to that effect, my lord, none of the reports has opined anything. Only they proceeded only my scratch marks. But this is much. And my lord, second thing, my lord, prior to that page 42.
Mr.
But-
Rai, we have already.
I'm sorry, my lord. But
Such a
but
senior lawyer
pa-
like you.
page 4, paragraph 14, your lordship once, my lord, have a look. Next, very previous page, page 42,
Yes.
clause 14, my lord.
42.
My lord. Clause 14, my lord.
Validity of recruitment medical. You have tried your best, Mr. Roy. We also feel sad to reject your case, but what can be done
My
with
lord,
bound
my lord,
word?
I cannot improve my case, but my lord, only one thing, my lord, that so far as these boys' honesty, my lord, troubled me, because it is nowadays he can change any version he can produce, and then he will be qualified.
All right. Yes, next.
I am appearing for the respondent and application.
6, in item number 6, the name of the matter has been wrongly printed.
Lord, I appear on yes, Lord,
You
I
are
take
in
it
the you are in the matter which has been printed.
no,
WP.
item 6.
Item 6.
Item 6. Kindly take it on next Monday.
Okay.
6.
No, Mr. Bhattacharya, this matter has wrongly appeared. এইটা তো আসেনি, ওইটা অন্যটা. It will go out. It has not in place and stead of the correct matter. This WPST instead of WPST 159, they have listed WPCT 150.
Very well, my lord, may I only appeal one thing to my lords? My lord, subject to what falls for my lord's kind consideration. If it appears in the next, on Monday next, very well, or if it appears after vacation, but kindly give that direction, because my lord, otherwise, my
Let
lord,
it come, let it come.
very well.
This has wrongly appeared.
I
If
am
anybody mentions it will come, then we will hear it.
very well. I'm good.
Yes.
I'm good.
This person.
Kindly do not mark me.
জায়গা চেঞ্জ করতে হবে।
How you are keeping, Mr. Bhattacharya? Now you are all right.
Looking after the health.
You must take advice from Mr. Mukherjee.
There is somebody is there to look after Mr. Bhattacharya, but should not be disclosed anywhere.
Oh, he's pulling your legs. Yes, yes.
My lord, I am for the respondent, and
Respondent.
an application is also made by me. On previous occasion, your lordship was pleased to direct to take the instruction from my client and also from the client of Mr. Mukherjee. My lord, what we have, my lord, sorted out, that is, my lord, keeping all point, if it can be remanded back to the tribunal, then my lord, we are agreed. Otherwise, my lord, I will fight by way of filing affidavit in opposition. Because, my lord, there are some points.
Say again, you changed your opinion.
Yes, my lord, because undertaking, my client or I am not willing to give any undertaking that these points will not be taken up. Because this point is also viable to be taken up by me. That argument I have, my lord, I have advanced. I have gone through, I have made the research work that I am eligible.
So what do you want, Ms.
My lord, because my lord, I will show from the writ petition even, they have also admitted by way of aberment.
No. If Mr. Bhattacharya, you want, your earlier argument was that I am withdrawing that challenge as regards.
No, now I am not withdrawing.
So now you have changed your
Because,
mind.
but my lord, the judgment has not made on merits. That is admitted by the petitioner also.
File your affidavit.
Only one point has been taken up.
It was decided on affidavits.
No, this is the first time, my lord. Only
No, before the tribunal, it was decided.
Yes,
on.
Yes, on
Yes.
completion of affidavits.
Yes.
When we have taken all the points before that tribunal has not.
But my lord, ultimately, because only one point, presenting officer point, appointment of presenting officer point was taken up by the tribunal itself. But my lord, by way of aberment or pleadings, what are the points I had taken there? Nothing has been touched even, whispered or touched even, and that has been admitted by the writ petitioner here also. By way of aberment, I will show before your lordship.
Unless you cross this hurdle, Ms. Bhattacharya, how can the tribunal look into the other issue?
Yes, that
Unless you cross that hurdle.
Yes.
Then
Well, let it be decided by the honorable court, because again it will be remanded back and again it will take some time. By way of affidavit, let it be, because I have a very good case in respect of disciplinary proceedings. There are every possibility to win in disciplinary proceedings. But what
Also, records reveal that by an earlier ordered by an ordered.
But if without undertaking it is remanded back, my lord, I have no objection there. Keeping all point open.
How can it be done? Because there is a coordinate bench judgment.
My lord, that is, my lord, that is different. I will show before you. Let him, my lord, place.
He has, his argument is based, he has placed reliance upon that.
Yes.
So if that we do not accept,
Yes.
we have to refer it to a division higher.
No, my lord, that may not be required, my lord. Let him place. I will distinguish that judgment. I will distinguish that judgment.
So that is a matter to be heard finally.
Yes,
How can we relegate it to the
Yes,
tribunal
as
and
your
say,
lordship, as your lordship.
decide whether the High Court order is
No,
right?
no,
We
as-
cannot do so.
No, as your lordship.
Is Bhattacharya learned advocate appearing for the respondents prays for leave to file an affidavit in opposition to the stay application. So let such affidavit in opposition be filed within a week after the vacation.
Yes,
Reply thereto, if any, be filed within a week thereafter.
Yes.
List the matter for final hearing in the combined monthly list of February 2024. Stop. The interim order passed earlier is extended till the disposal of the writ.
My lord, then my lord, let it be, one date may be fixed, my lord. Otherwise, monthly list, my lord, it may not, my lord, be touched.
Monthly, no, you come and mention, we will fix a date and take
My lord,
it.
if the determination changes, my lord, then it will be problem. My lord, let a date be fixed.
How can we pass a mandamus that don't change our determination?
No, no. For that reason, my lord, kindly fix a date. Kindly fix a date, then the matter will come. Otherwise, my lord, your lordship knows the situation, and I am financially, I am losing.
Oh, we have already passed a direction for affidavits. You have not passed, that direction is already there.
On the first date, we
Parties
didn't
will be
appear.
at liberty to exchange their affidavits, we said.
Yes, then my lord, date, perhaps the date has been fixed there also.
Ms. Bhattacharjee
Date may be extended.
কোন
Ms.
date আছে?
Bhattacharjee learned
ওটা তো
advocate
পেয়ে গেছে।
appearing for
হ্যাঁ।
respondents,
বেরিয়ে গেছে?
place for extension of time to file the affidavit in opposition.
Yes.
Let such affidavit in opposition be filed within 2 weeks after the vacation, reply thereto within a week thereafter. List the matter in the combined, for final hearing in the combined monthly list of February 2000.
My lord, late date of February be, my lord, there.
Of the interim order passed earlier is extended till the end of March 2024.
My lord, late date we fix. My lord, otherwise matter
If
will
we
not.
have extended it till March, it will be their agony to come and pray for extension. It is not reached, you mentioned.
Or kindly dispose of the writ petition, but interim order may be extended till the dispose of the writ petition.
No, we have kept it up to end of March. It will come in every day. If we cannot take it up, we will extend. Yes. So, Mr. Ghosh, we will send back the matter to the tribunal. Let the validity of the decision be tested before the tribunal. Kind of. His contention is recovery has been restricted.
And that
The
amount is,
order by which the recovery was made,
and
that
that,
order has not been
and
taken.
that recovery amount, that portion, that is already, my lord, refunded to the petitioner also.
We will record that. But the issue as regards
Basic.
validity of the order by which it was
Fixation of the
Basic.
that has not been
Deduction of
And my
basic.
lord, kindly record my just one line submission that
Here the recovery from the previous order, but whether that order is sustainable or not. Yes. Even that order is there, then he will get it in his lower scale. Where is your original application prayer? Prayer in the original application?
Original application.
Page 30.
Page 34.
Return the deducted amount.
কোথায় 34 তে নেই?
34.
Original application page যেটা
34, my lord. Kindly come to the page 34.
আচ্ছা 34.
Where is that order? That order you have not challenged. Order reducing your pay has not been challenged.
No.
অর্ডার কিছু ছিল না, কারণ সেটা আমার পেনশন পেমেন্ট অর্ডারের কানেকশনে এসেছে।
They did not pass any independent order.
No, order has been passed with the direction to refund the discharge amount.
Where is that?
সেটা তো ট্রাইব্যুনালে
Tribunal.
পেনাল্টি করার কোনো কিছু
What were
বেসিক রিডাকশনের কোনো অর্ডার নেই
Basic reduction e kono order nei, no order. After retirement, they came to know that the basic has been deducted. After retirement, on the very date of retirement, when they got the PPO, pension payment order, they are saying that basic has been by 3,900 has been deducted.
then in their affidavit in opposition, what is their stand?
Opposition, they have just only gave the recasting of the,
They have to do all homework.
they have not given any reply to that also.
MACP they have miscalculated and thereafter they have
Actually, they are telling one MACP reply, page,
page
86.
Yes.
Page 86, in their reply with regards to a statement, contention made in paragraphs of the said application, the same is not true, hence denied, dispute, save and accept what is matter. The opponent submits herein that in terms of
Now they said that we have asked for that recovery since he was entitled to a scale of ₹10, but he was erroneously given a scale of ₹12. Now are you now paying? Which pay scale you are now paying? The reduced pay scale pension you are paying, or the
he is paying the total pension on that reduced basic pay. And all the pension benefits has also been calculated on that reduced basic pay.
how will we understand that?
Actually, his pay scale was 68,000. Last pay slip has been annexed.
So you have nothing more to say as regards the stand of the respondent. We decide the matter here. Tell us.
Very good judgment is there, my lord. May please see.
Listen, sir, judgment comes after the facts are placed. Don't jump to a conclusion. Very good judgments are there, we know.
And if your lordship, my lord, wants to send back the remanded back the matter before the tribunal, even then, my lord, I have no objection.
No, but we cannot, there is no specific order of reversion. You have calculated automatically the benefits on the basis of a reduced pay scale. How can you do that? You have to justify your stand.
My lord, specific statement is there and that.
So we will decide it finally. You are not ready today?
Yes, I'm ready.
So place your case.
Page 70.
Mr. Ghosh, you have no other document to be placed on record, you are sure?
Yes, my lord. 2-3 documents I have to, my lord.
Not pass any order for reversion.
On the date of retirement, my lord, pay was refixed.
Pay was
Yes.
refixed on what basis? There must be a decision.
Yes.
Where
My
is
lord,
that decision?
that documents, my lord, I have to, my lord, annex, my lord. I have to show, my lord.
That you have not
Yes,
stated in your.
I have not find, my lord.
No, reply
But
they have.
reasoning is there. Admittedly, my lord, he is entitled for the pay scale of 64,100. But that was wrongly fixed 68,000.
What further document you want to rely upon? There
That
no-
is why they have decided to refix the pay scale of
Yes.
64,100. That documents, my lord. That is, I think, my lord, hardly, my lord, 7-8 pages.
No, because we said that the matter has been decided upon affidavits, we can finally
Yes, yes.
hear the matter.
Yes, that was, my lord.
Then you do one thing. Which are the documents you are relying upon? What documents you want to rely upon?
My lord, the documents, my lord, that MACP, regarding the MACP, which was, my lord, on the wrong date, that was calculated, my lord.
In reply, they are telling,
Where is this memo of 17 January 2018? Kindly come to page 86.
My lord,
What is your step?
that is your lordship rightly, my lord, pointed out. That document's in my hand, my lord. That
Yes,
is not
yes,
here.
That document you did not enclose here.
No, my lord.
Then you give a copy of that document to your friend.
actually, that recasting I have got in the reply, but why the MACP has been cancelled on the very of the retirement? Why they did not take the decision?
My lord, that was not challenged.
He got the MACP
My
in the
lord,
year 2008.
That was not challenged before the learned tribunal.
All the challenge.
Why the MACP was cancelled?
How
My
you
lord,
can
that
challenge?
was not under challenge.
How you can challenge?
Yes, place your case.
My lord, my scale was 68,000 on the very date of retirement. Just may you please see the pay slip as issued by them? Page 39, before that. January, I have got the salary on the basic pay of 68,000.
When did you retire?
I retired on 22. Yes, 22, 20.
No, 28th of February 2018, he retired.
Yeah.
Yes.
Yes.
Till to date, I got the salary on the basic pay of 63,000. On the very rate of retirement, I came to know that my basic pay.
Understood. Now go forward. Please.
Thereafter,
when was this pension payment order issued?
Pension payment was 39. May Lord, please see 39. May please see 39. Page 39. PPO.
Last pay level 64.
20. Here it has been 64,100.
And where is the recovery amount stated here?
Recovery amount stated. Page 40, 2,92,515 deposit pension. Here is indicated deposit pension. Actually, that has been deducted. 2,92,515. Page 40.
This was the overdrawn.
As per their statement.
And that is my lord, already
That has
refunded,
been
my lord.
refunded. That is the frequency case. There is an alternative.
Your deduction was 3,46,515.
No, that is really leverage health scheme. Actually, our scheme is here.
Read page 40, first paragraph. Read it.
Total amount 3 lakhs for total lakhs 3,46,515. Actually, health scheme, our health scheme is already been deposited. Last payment has to be deposited. That's why they have taken 54,000. That is insurance scheme, health insurance scheme. Really, just 2016, this scheme has been introduced by the railway. The last payment has to be deposited. Last basic thing.
Yes. Now, what is their case? What is your case? Tell us. On the date of retirement, you refixed his scale in a lower scale
Yes. My lord,
without giving any opportunity, without calling him nothing.
no. Without
Then
giving,
what is your stand?
my lord, my stand is, my lord, according to the railway rules, my lord, that can be done. And my lord,
Show us that that
yes.
was done. Where
Yes,
is
sir.
that order?
দুটো দাও
দাও দাও।
থাক না ওটা থাক না Actually, my lord, that is my instruction for this decision. On page is in handwriting, my lord.
No, no, this way we cannot take up. kya?
Next page, my lord. Ita. Just now, what your lordship is asked, my lord, what was the order of 17 January 2018? That is, my lord. দিচ্ছি
Now, the 17 January 2018, that is referred to in your pleadings.
Yes, my lord. My pleadings, my lord, from page.
Very good. You then enclose this document.
No, my lord, that was not enclosed.
Then you have to, then we allow him to bring this on. Yes, sir. No, nothing. This order was also not communicated. Where you communicated this order of 17 January 2018?
No, we have not got any communication before the getting that PPO.
Even after. Mr. Ghosh, learned advocate appearing for the respondents, prays for leave to file a short affidavit in opposition to bring on record the documents as referred to in the reply filed by the respondents before the learned tribe. Stop. Such prayer is considered.
And my lord, if any additional document, if required, my lord.
Clearly clear, Mr. Ghosh. As documents as referred to in the reply filed by the respondents before the learned tribe. Stop. Such prayer is considered and allowed. Let such affidavit in opposition be filed within a week after the vacation. Reply thereto, if any, be filed within a week thereafter. Stop. List the matter for final hearing in the combined monthly list of February 2024. Yes, next.
My lord,
Take back these documents.
My lord, only one thing, my lord, documents relied in the reply and.
No further documents. Only you have to annex the order of 17 January, which you have referred. Yes.
Item number 9 is similar, my lord.
My lord, may I take back those?
Yes. ওনাকে ওই কাগজগুলো ফেরত দিয়ে দাও।
This
Similar.
নাইনে কে আছেন?
নাইনে আমি জানি। আমারটা এই
আচ্ছা।
This is the same matter, na?
Same matter, madam.
Same order করে দাও।
I am for the response.
Yes.
Lordship, I am for the report.
Lordship, petitioners, before your lordship, is a casual worker directly engaged under Archaeological Survey of India at Kalna Subcircle and working at Guptipara, Brindaban Chandra Mandir. Lordship, your petitioner was engaged on 2012. On 17th July 2017, the respondents suddenly, without serving any notice of termination, discontinued him from the service. He was enrolled in a master role. Prior to that, he made a representation before the authority for their 130th status. 130th status, so far I have understand, Lordship, this is a pay scale. In the representation earlier, they made before the authority that we are entitled to the 130th status, so provide us that. To that effect, on earlier occasion, there was a application was moved under section 19 of the Administrative Tribunals Act. There was a direction. Subsequently, on 2015, Director, Government of India, Archaeological Survey issued an order for restriction and enjoying further casual laborers. Lordship, that is at page 45 of my application.
When were you terminated?
On 17th,
17th
2017, July 2017.
July 2017.
17.
So you challenged that termination before the tribunal
Yes.
by
Honest,
filing an application in
the
2000
latest original application which was moved before the tribunal.
is 2018.
Yes. On that original application.
So when was that ordered of termination? Any order
No
of
termination, no written termination was there. I was verbally restricted to join my duty. I was a master role casual employee. And
So when did that happen?
on 17th July 2017.
17th July 2017.
No order is there, Lordship. I have challenged my disengagement before the tribunal that we are disengaged on punitive measure.
Sir, you were engaged as a casual labor.
Yes, Lordship.
So there is no appointment letter.
My name was there in the master roll.
Go to the industrial tribunal. What were you doing in the
My lord,
central administrative tribunal?
casual labor is working 4 years. As a 4 years.
Lordship, I am coming.
Master
Lordship.
roll, then you have to produce all those documents. You're aware
Yes,
of
Lordship.
the, what is the rule of master roll?
My point was there before the tribunal that I have been disengaged.
May I, Lord,
See, the
may I-
moment you use
may I-
the word master roll, then you have to lead evidence to
May
that
I
effect.
submit? May I
Show
submit?
that how long you have worked on the master roll.
That is
What
the-
that will be dealt.
At the time of
Madam,
casual
sir,
labor appointment.
hearings, please take your seat.
All right.
So,
Lordship.
that he has been disengaged on the basis of a report of the general that he had lodged a false complaint against that person. His disengagement was not due to scarcity of water. No, sir. This is central administration. This is not right. You are a captain. You have no right to go before the central administrative tribunal. You have no
order, paragraph 6 and 9. It will be clear. Paragraph 6 and 9. And I have replied.
Where is the order of the regional director?
Yes, Lordship.
Where?
Page 117. May I read it for your Lordship?
117.
What is your name?
Lordship, my name is Probir Singh and another one is Sudhanshu Bishwas.
That is the 11726 Subhash Chand, section officers, vigilance. হ্যাঁ হ্যাঁ ভেতরে লেখা আছে যে এটা চিঠিটা ওকে দিয়েছে।
Immediately discontinue. How can you do so?
Two levers.
Now Madhavi has come. If you want to stop the or close the door, you have to totally close it. But after that,
That is at 74. Starting from 74.
page 74.
Page 74.
Add this to Sri Nepal Das.
So in this page 74, did they refer to the order passed by the regional director?
No.
The regional director's order was 23rd June 2017.
20.
Page 170.
Yes, Lordship.
And this order was passed in 2018.
Yes, Lordship.
Here they have denied your claim since you are
My 130th status. And
but sir,
read with 15 notification.
You have to, what are the rules that your case before the tribunal was that you are throwing me out on the basis of a report of the regional director, which is penal in nature.
Yes.
Now, when they passed the order, they took a stand that you cannot come now, since the ministry has taken a decision that we have to float a tender for bringing in casual.
Yes, through e-tender.
So you show us that a per se a casual labor cannot be thrown out on the basis of a finding in a complaint. Your whole case is that you have not granted me any opportunity.
Yes, Lordship.
You have not granted. So this point you ought to have raised in your first original application.
Lordship, in this original application,
The original application on the
196.
The original application on the basis of which the speaking order was passed.
At that point of
Yes.
At that point of time,
Hmm.
this order, I was not debarred at that point of time.
Then why did you approach the tribunal for giving you
For
temporary
at
status?
that point of time, we are on our 138th status. We are concerned with our 138th status.
That is temporary status.
Thereafter,
But ultimately you can be
Lordship,
regular.
kindly come to page 45. I made a specific complaint against few persons. No, before that, Lordship, kindly page 45, what the government order says with regard to restriction of whether, how far that is applicable to us. Page
policy matter.
আমাকে একটু বলতে
Policy matter. This is a purely policy matter of the court.
Okay, thank you, sir. 46. Restriction on engaging casual laborers, granting 130th status and temporary status to casual laborers. Find enclosed herewith a copy of such and such, dated 24th August 2015, on the subject cited above, in view of which all conservation assistants foremen are hereby instructed not to engage any casual workers in addition in the list already. So I was there before issuing of this 2015 notification.
Where you are reading?
Third line, Lordship. Page 46. Are hereby instructed not to engage any casual worker in addition to the list already. So, before issuing of this notification, those are there in the list, they will remain. Thereafter, no casual workers are restricted. And subsequent 138th status is restricted, to my understanding, Lordship. Thereafter, page 47. Office memorandum, subject recruitment of casual workers and persons on daily wages. The undersigned is directed to refer the provisions of the Department of Personnel and Training, OM dated such and such, on recruitment of casual workers and daily wages. Attention is invited to the provisions of the referred OM at para 1 III, which lays down that work presently being done by regular staff should be reassessed by the administrative departments concerned for output and productivity, so that the work being done by the casual workers should be entrusted to the regular employees. We are regular employees.
Could be entrusted. Could be. Show us the now.
Thereafter, this is also of 2016.
Now that was, then you made a prayer for when you were continuing in the list. When you were thrown out?
No, order was passed, Lordship. I was
Where is
thrown
your
out on 17th July 2017.
17 July 2017, that is your 17 July 2017, you were ousted.
Yes.
But the order,
Disengaged.
disengaged. And the order of the regional director was 23rd of June 2017.
Yes.
So on the basis of that order, you were ousted.
Yes.
Now, when did you file the original application, earlier original application?
Sir, where? They even made representation. You are not. True.
Which order? Their order. You bring the first original application.
Look all the.
First original application, Lordship.
This is the original application.
Nepal Bush. ওই অর্ডারটা কোথায় আছে পুরোটা নেই
Officers. This will Japanese instance. Petitioners has the respondent says for reservation to So when you do not challenge a finding reached by the tribunal, these poor people finding what their jobs. See, in the reason that this is something else. Tribunal attends a finding.
That's let him get this. Let him get the way. Let him find the way. The first way.
Lordship, prior to that, Lordship, if your Lordship kindly peruse page 48 once.
Original application.
Mr. Mukherjee,
Yes.
Your story is that you are no longer a casual employee. 138 status and temporary status cannot be given to you. Rightly discontinued. This is your story. That is what you have said in your speaking order also.
Yes.
Now, in terms of the central government order, e-tender is being floated for engagement of persons in casual work.
Not this is order. This is a policy matter of central government.
Understood.
When you are
No, we are not saying your action is wrong. Our query is, we are asking a question to you.
Yes, my lord.
Tribunal has said.
Yes. Tribunal kindly see the paragraph 6 and 9.
Paragraph 6 is
and
your
9.
submission. Now kindly come to paragraph 8.
Yes.
Kindly come to paragraph 8. Paragraph 8, hard line, before being disengaged, you got it? Before being disengaged?
Yes, before being disengaged.
He had raised the issue of alleged irregularity in engagement of one Sujit
By casual labor, yes.
As casual, by the local
Yes,
authority, resulting in a general complaint by other casuals with the vigilance department of
yes,
SL.
yes.
This complaint was inquired into by the regional director,
Yes.
who found no merit in the complaint. Now, very important. Instead, she held that the applicant and other twos were responsible for instigating the complaint. An order was issued by the director to discontinue the service of the applicant.
Yes.
So, tribunal arrived at a finding that you have discontinued his engagement on the basis of the order of the regional director. So this, Mr. Mukherjee, is a penal action you are taking. In the speaking order, your stand was, you were absolutely right, that now what can we do? Central government has said that you float e-tender and take persons. But Mr. Mukherjee, the tribunal order you have not challenged. It is their challenge. Then how do you wriggle out of this position? When you are throwing a casual worker, he is a person having 200 rupees, 300 rupees salary. You are throwing him out actually on the basis of a complaint he lodged against in your superior officer.
All right, may I submit?
Yes.
Yes. When he was appointed as a casual labor, that's a requirement of the authority. But now at position, no requirement of the authority.
But still you are engaging upon floating e-tender. This is you are victimizing him.
No question of victimizing.
No, Mr. Mukherjee, I think you have understood the
Please
query
give me,
which
I have no instruction in this matter. Please give me instruction. Finally file an opposition and reply, lordships, in this matter. Yeah, and I am not engaging directly. I am engaging not directly.
If you had made such finding, can be tried, and if you have made such finding, that is why he is before us. Yes,
Yes, yes, not, yes, not.
Mr. Mukherjee, you take
not-
instruction. You take instruction.
Yes,
It's only
take
one
instruction.
person.
Yes.
There is a necessity for engaging. You are holding e-tender processes. So why will you? A superior officer says, do not engage him. But if you can rightly disengage him, but I am entitled to an opportunity. The officer could have called me that, Mr. Mukherjee, what is your difficulty? Then you could have explained yourself.
Give me the instruction, and lordship directed the opposition and reply, and there in the meantime, lordships.
Opposition reply already there.
No.
In the tribunal, it is already there.
Yeah,
You have no more.
tribunal is there. But this court, high court is not there.
We're not engaging directly, lordship.
Wait. Your senior is Mr. Mukherjee.
I can
Never argue when a senior is there. Yes, you take instruction and come. This is a point which has to be considered. Or Mr. Mukherjee, you can apply your good office and just find out whether this person can be inducted or not.
Without instruction, I cannot say in this respect. I cannot.
And you bring your original OA, the
Lordship,
earlier original
certainly, Lordship, but that with regard to 138th status. Only with 138th status. And the
My
subsequent,
brother has gone through your entire original application. There, not a line you
Yes.
have written.
yes,
Not a line you have
with
written.
regard to this
highlighting.
complaint, but in the subsequent original application,
Not subsequent,
You
previous.
show me from your entire pleading, one line where you have taken this argument. Entire
which
pleading.
argument?
The argument that the action has been taken based on the direction of the
Regional director.
region. One line. In your writ, in your OA, anywhere. One line.
77.
Tribunal has-
My original application of 2018. Lordship, Lordship.
From
You
the
don't
entire
understand
pleading.
what my brother is saying.
Yes, Lordship.
Then why you are
From your
repeating?
entire pleading.
Hmm.
Your entire case is that
May I-
other people were being engaged and he has been removed.
Lordship.
Some XYZ officer was taking money
Lordship.
and engaging other people, but he
Lordship.
has been removed.
Original application is starting from page 77, Lordship. Page 87, Lordship.
Yes. Read 4.4
4.4.
in the middle.
The applicant states suddenly, without serving any notice of termination, the respondent authority discontinued him from his service on and from 17/7/27.
Read further.
Though the applicant apprehends that it may be the aftermath of hostility of Kalna subdivision sub-circle in charge, since he, along with other 12 casual laborers, made a joint complaint
Read further, sir.
against one Gangadhar Das
and
and
Arnab Das,
that
Or one
who were
Arnab
rendering
Das?
illegal appointments.
Yes.
To one Sujit Biswas, son of late so-and-so, dehodes the settled rule and various orders issued by the department from time to time.
Yes.
This is your entire case.
Yes.
Your case is not that the lady has conducted an inquiry and because of the inquiry you have been removed.
That was not
Nowhere,
known to me.
not even a
That
word.
was not known to me.
How will it not be known to you?
Okay, you filed
Lordship,
RTIs.
Lordship, it is their respondents
You filed RTIs.
reply before the tribunal.
What is the tenor and tone of your RTIs? You have filed RTIs, right?
Yes, Lordship.
What is the tenor and tone?
Why I have been removed, disengaged?
That's all.
Yes. And Lordship, kindly see page 120 onwards.
All right.
It
let
is
them
the
come back with the
rejoinder of the respondents, and these documents they have.
Their own way.
It was never within my custody.
Where is the original application?
Starting from page 77.
Recent order was passed. OA 551 of 2018.
Uh,
74.
Page 74 is the recent order.
Recent order passed on the basis of an original application.
Order that I have annexed, but
Bring us that
yes.
original.
And Lordship, one more interesting fact I will show your Lordship.
Will become disinterested if we pass order against you. So it is better you produce that document.
Obliged Lordship, but if your Lordship kindly see one page, Lordship.
Sir, don't show any more pages.
The learned
It will not
advocate
help.
Out of 13 casual laborers,
may I-
only
may
2
I
have been
submit one
disengaged.
Is directed to place before this court the earlier original application being OA number 551 of 2018. On the next date of hearing, stop. Mr. Mukherjee, learned advocate, appearing for the respondents. Yes, his name is already there. Mr. Mukherjee, learned advocate, appearing for the Union of India, is also directed to even necessary instruction. Stop. Please, the matter for further consideration in the daily supplementary install this goes on. 16th January.
May I submit one thing? May I submit one thing? My lord,
Appearance to the solicitor.
on submission before your lordships.
Make 2 submissions.
No, kindly see the order of the learned tribunal,
We will
page
sit
7.
on that. We have
This is
explained.
observation of the learned tribunal.
Mr.
Kindly see.
Mukherjee, you are a senior person. We have told you where lies the pain. Where it is itching, we have shown you that area. So you better tell your authorities to consider that and come back with instruction.
No, that I am
Only
submitting.
one person is there. What will be the problem to you?
That I
If you
am-
can,
that
this
is the
is casual laborer. You will engage him for 50 days, then
See,
throw him
Mr.
out.
Mukherjee, if we get into it and we say that the number of casual employees who were engaged with him were 13 or 15, and you have selectively removed only 2 based on the complaint and the inquiry which was done, where they have not been given any opportunity, it's a punitive action which you have taken. So please take instruction to that effect. It's a punitive action. If you would have removed every single casual laborer with them who were employed, then I can still understand. You have taken a pick and choose policy and removed only 2. This has to be answered.
Obliged.
Kindly see the observation of the learned tribunal. I am reading lordship, kindly see. Casual labor by ASI, the right to continued engagement accordance to the applicant under
Obliged.
the term of employment. And the issue of complaint, but
It's okay, Mr. Mukherjee, you come back with it. It's okay.
We have told you what instruction we
Yes.
want. Kindly come. Yes, next.
Next date কবে বললো? January.
Item number 12, my lord, I am appearing for the respondent.
Lordships.
For the petitioner, my lord.
I apologize. Regret. In between, I have interfered.
You're a junior man. You should know this.
Yes, too junior, too senior.
Excited.
Yes, lordships.
Once it so happened with me also, you people become over enthusiastic about the matter. You are not the client. You are an legal officer. You are an officer of this court. So don't identify yourself with your client. This is a basic thing which you have to learn. Maybe your senior is saying something which may not be, is not being acceptable to the court. That is why over enthusiasm you jump up and start, sir. This is very wrong. This is not professional ethic.
Yes, your appreciation is very.
Yes.
My lord. My lord, I am for the petitioner, my lord. This is a matter regarding MSCP, my lord. The issue is twofold, my lord. One is
Mr. Das, come back after vacation. MSCP matters we have kept, we will take up together.
my lord, the applicant has retired in 2013, my lord.
Very good. We are keeping it. We are keeping it. MSCP matters will be taken up. We will hear it to you. This is what they are in MSCP, in the old assured career progression. No.
Yes.
Now this modified plan.
Yes.
Now this on the basis of this modification, that 10 years have now been changed to 12.
Correct, sir. 12.
Now there
12 and
rises a
24.
distinction of pay scale. Now Madras High Court has delivered a judgment. There is a judgment of our court
But this
also.
is also-
Delhi High Court has also.
I have
You have done.
cases I have argued.
দিতে হবে আমি অ্যাডভোকেট রেকর্ড আছে দিতে হবে
From the point of isolated process. There's something on isolated process where they don't have the knowledge of any particular. When that it is calculated in a different way.
Yes, yes. January it will appear. 15th January.
Thank you.
You get on that date, you take instruction.
My lord, I'm praying for short passover on behalf of.
You are the
My lord, we are the Union of India, that is petitioner in this case.
petitioner.
Yes, your lordship.
All right, let your senior, what is the matter?
Disciplinary proceeding.
Disciplinary proceeding.
Yes.
It will take short time.
It's
subject
very
to what
short
they will
time
decide.
actually. Very
Short
short
time?
Yes.
It will. I not say anything.
Oh, you don't want to do the matter?
No, I do it. I said it will take a short time. I think so.
You start. You start.
Lordship, my file is with the clerk, my lord. Just short passover, my lord.
What? It is a termination.
No. The departmental proceeding, which portion of it, the punishment, etc., has been set aside, and they have been allowed to proceed afresh if they so desire. Nothing much as such.
Their Union of India is aggrieved by such direction.
Yes. Yes, your lordship.
Let him come, my lord. We'll finish it off today itself because it's
Yes,
not-
your lordship. Come.
Though the brief is quite heavy, it looks, but it's a very short thing.
Reply rejoined.
What was the allegation against you?
Allegation against her was that in the exam hall she had tried to help and all these things, but it has been found.
So the punishment order was set aside.
Set aside.
Granting them liberty to come afresh.
Proceed in accordance with law from the stage of the
charge sheet.
From the
inquiry.
Yes. Lordship gives me a minute.
What was the penalty given? Reduction in pay?
Yes.
So you are now enjoying the reduced pay. Huh? You are continuing to enjoy the reduced pay.
The inquiry report and consequent penalty and appellate orders are quashed with liberty to act in accordance with law.
What was the punishment imposed?
One increment, 2 increment down initially, the appellate authority said 1 increment.
Take it up. So where is your senior?
My lord, he's at Lex in court number 22. Just give me 10 minutes. He will come.
Not this week. Then.
Lord, then kindly takes up on Monday, Lord, subject to my Lord's pleasure.
Next week it will appear.
Lord.
Yes.
My lord, in this matter, I am led by Mr. Shomo Mujumdar. My lord, he is out of station. He is returning today. My lord, he made a request if this can be taken up in the next week.
Oh, 1 week after vacation. Yes, come.
Kindly fix up a date, my lord.
It will appear 1 week after the vacation.
If
Item number 16.
Yes.
I'm for the respondent.
For the respondent, Mr. Ali. Who is for the petitioner? Rudrojit Bhattacharya. Where is
In this
Rudrojit?
matter, I am for the petitioner.
Where is he? He has come. Yes, Mr. Bhattacharya.
This is regarding selection to the post of junior engineer from the group of inter apprenticeship quota. There are three categories of selection.
Let us come to the order of the tribunal.
Yes. Lordship may find it at page.
You are Union of India, and who is your Mr. Ali? You are appearing for all the respondents. You are for all the respondents.
No, I am for 5 and 6.
5 and 6.
Yes.
So who is for
Only two.
Sanjay Kole? Oh, why you are so quiet?
Page 17.
P7, next year P7.
My lord, the order begins from page 17.
Judgment.
Further order petitioner page 17. Petitioner
WPC ওখান শুরু হচ্ছে স্টার্ট করতে WPC টিভি
সায়নী রায়চৌধুরীকে পেয়েছেন
কিছু সাপ্লিমেন্টারি এফিডেভিট
হ্যাঁ একটা সাপ্লিমেন্টারি পিটিশনটা করছি
মেন পিটিশনটা
হ্যাঁ হ্যাঁ মেন পিটিশন দিয়েছি এই যে This also. So, এটা দেখুন। ট্রেনে যাবে তো আধা ঘন্টা
আশা করছি
ট্রেনে
Yes.
So the issue is whether seniority marks have to be added on.
Yes.
This is the issue.
My lord, I want to start from the advertisement inviting the volunteers to apply for the post. That
Yes.
is at page 14.
1/4.
1/4.
Now, what is the panel which was prepared prior to the tribunal's order?
Yes.
They have got appointment.
They are already
6%.
promotion. Promotion they have not been
Tribunal directed recast the panel.
Yes.
The panel which you prepared,
That has not been discussed.
the panel which was prepared were 6 general, 1 SC.
Yes. Yes.
So out of those 6 general, he was the 7th general. So he did not get.
Yes.
Now those 6 persons have already been given the promotional post.
No.
You are sure?
Yes,
Mr. Ali is appearing for them.
5 and 6. Two of those promotees.
Have you been promoted, Mr. Ali? Have you been promoted?
No.
Well, it is my learned friend was referring to.
No, we were only asking, wanting to know
Yes.
that in the panel which was prepared, 6 persons from general category were there.
Yes.
2 of them were your clients, I think.
5 and 6.
So have they been given the promotional post? Panel has taken effect or not?
Well, this promotional process is started with a particular notification.
Though,
The
so you have
promotional
not
process.
yet been promoted.
No, my lord.
No. The notification was issued. It's there. This is a promotional selection for filling up of the post of junior engineer.
No, Mr. Ali,
In
we
electric.
understand that. Mr. Bhattacharya, you can answer this question.
I am assuring your lordship that the panel has not been given effect.
Oh, it has not
Been given effect, but it is preserved since the matter is pending before this honorable court.
So one person has stopped the promotion of six person.
yes.
This is the problem.
Yes.
Yes, come.
Page
tell us what-
14.
Huh?
Page 14, 1/4.
Yes.
This was the first
Notification.
page 14. Has your lordship got?
Yes.
Page 14. My lord, earlier selection for filling up the post of junior engineer in electrical trains within bracket M, that is mining, mechanical wing against 25% inter apprenticeship mechanical electrical
Vacancy গুলো বলো।
vacancy, yes, ওটা বলছি। This is vital, my lord, 25% inter apprentice mechanical electrical for the post unreserved 3, schedule caste 1, schedule type 2. Total earlier in the year 2011, it was for 6 posts. It was for 6 posts only.
That is 25% of the apprentice mechanic.
Yes, 25% from that category.
Right.
There are 3 categories. That
One part was for this is restricted to 25% from apprentice
Yes,
category.
yes.
Very good. Then what happened?
Thereafter, my lord, this notification was again modified, and page 15, that is page 15, for the same post from the same category, page 15, 1/5.
This is of 2018.
Yes.
Selection for post of junior engineer under TRS.
It is different. It is different.
It is another in following that notification. This notification was published.
We are concerned with which notification?
This 15, page 15, 1/5.
Yes.
Page 15. So why you are showing us page?
But no, from there it begins.
Very good. So here it is general category 6, schedule caste 1, ST 1.
Yes.
So this is selection for the post of junior engineer under TRS EMU department in grade pay such and such against 25% promotional.
Yes, my lord. This is very vital because in judgment, বলছি, আমি বলিনি।
Yes.
এইটাই দেখাও, এইটাই। The last paragraph.
Thereafter, my lord, I shall place before your lordship the selection category.
Just the 4th paragraph says that this may please be published widely amongst technical inspectors in TRS EMU Howrah only.
Howrah division.
Only Howrah.
Yes.
Not general.
So that all technical EMU wing Howrah division can be. So this is restricted to the district of Howrah.
Yes.
Yes.
Howrah division.
Now what happened? Now what happened?
The
page 16 is the provisional select list.
Yes.
Sanjay Bhattacharya, Sujit Haldar, Mintu, Shantanu, Sopon. Who is before us?
Yes, one is schedule caste there. That is serial number 3. Serial number 3 of this list is schedule caste.
Sanjay Kole. Sanjay Kole is before us.
Serial number 3.
Mihir Kumar Saha.
Mintu Kumar Saha. So 6 unreserved. 1.
We are asking Sanjay Kole is not here.
No.
No.
Sanjay Kole is not.
What we are asking you.
Yes.
So after you published in Howrah division, based on overall performance, the following candidates were recommended.
Yes. For promotion.
Being free under vision are hereby placed in panel provisionally for the junior against 25% promotion. Very good. Above section is provisional, subject to further action. Yes, then what happened?
My lord, this particular thing, the criteria of promotion, this apprenticeship, electrical, mechanical quota. That is also admitted position. OA, that is from supplementary affidavit, page 22, filed by the respondent number 1.
Page 22.
22 of supplementary affidavit.
Supplementary affidavit filed by whom?
By the petitioner, railway.
In this application?
Yes.
That is page 22.
22.
Running page?
Running page 17 of OA. Original application.
Have you got it? Yes, 22.
22.
Where you are reading?
22, my lord.
Page 22 of OA.
OA. First paragraph, from the last line, 6.
Yes.
The sentence begins with to the post of junior engineer. To the post of junior engineer in electrical, trans, mechanical wing against 25% inter-apprentice mechanical electrical quota. This is very important, my lord. This is admitted by the original applicant, Sanjay Kole, the respondent number 1 hearing. This is very vital. Why I am, that I shall explain before your lordship.
It is under the 25% quota.
Yes. Now, my lord, from the judgment.
My lord, it is not only 25% quota. Your lordship will kindly see on the top. Pay level 6 GP, rupees 4,200 against 25%.
We will come back to you, Mr. Ali. We shall come. Yes.
So, my lord, admittedly, the selection will be held from inter-apprenticeship quota. What is their qualification? Artisan, ITI, technician, from this category of staff, skilled staff.
Only from Howrah division.
Regarding this notification from Howrah division. Now, and that is the admitted position. Where from it has been shifted, that has misled the learned tribunal, which your lordship will find from page 20.
So, yes, tell us then what happened.
Page 20. So, this is the admitted position. Now, my lord, if your lordship kindly.
So for this 25% promotional quota,
yes,
what is the method of examination?
Yes, my lord, that I shall place before your lordship now.
Place it.
Page 20.
20.
20 of application.
Yes.
Page 20.
Page 20. Paragraph 3. This judgment in paragraph 3.
From the order you are placing.
Yes, yes. How the learned tribunal has misdirected itself.
That is a running page.
The supplementary. Go ahead.
Yes.
Page 20. Paragraph 3. Paragraph 3. Has your lordship got?
Yes.
At hearing, drawing our attention to the board circular dated 6 February 2014 as such and such, learned counsel for the applicant would urge that such selection should be termed as general selection. The selection was from inter at 25%.
Understood.
Yes.
Understood.
Here it has.
So it should be general selection. That is why para C will apply.
If it is general selection.
So para C will apply.
That I shall place before your lordship now. And in terms of para C, therein this the tribunal has held. Now, my lord, in the table it has been placed A, para A, in tabular form. In table form, my lord, it is mentioned selection of post as per avenue of promotion by restricting field of eligibility to 1:3 times.
No, he says that seniority, towards seniority, no marks has to be granted. It is purely
that is the wrong.
His case was that as it is a general selection, you cannot grant marks towards seniority. Is that his case?
Yeah,
Is
no, that is his case.
We are wanting to know.
Yes, he has
his case. Then why he is placing reliance upon para C?
Para C, because
para C says selection without seniority marks.
Yes, and that he wants to.
Exactly. And
he wants to place reliance. They want to place reliance. He wants to place reliance.
Yes.
The marks that is
this is not a general selection. It's a promotional post. 25%. Yes.
My lord, here I am trying to clarify.
Para A.
Para A. Why para A? The petitioner stand in pleading and at the time of arguing was different. In pleading it is admitted. I have shown your lordship. Supplementary affidavit, page 22.
This is against 25% inter-apprentice quota.
Yes, that is his admitted position in pleading. And that is the notification. That is the notification. Now, my lord, if I place before your lordship para A first, I shall read all the paras, relevant paras. Para A. Selection of post as per avenue of promotion by restricting field of eligibility. In the right hand column, normal selection with seniority marks and 60% marks in the aggregate, including marks of written examination, record of service, and seniority. Panel being made as per seniority. Here, seniority has the importance, very important criteria. Panel being made as per seniority with 80% and above classified as outstanding. The person who has scored 80%, he will be treated as outstanding and he is allowed to supersede 50% of the candidates. Outstanding in order of their seniority, allowing them to supersede not more than 50% of total field of eligibility. This A is para A.
According to you, para A is applicable.
According to me, para A is only applicable.
Yes.
Nothing else. Now, my lord, why para A and para B? Para B I am reading. Selection to post as per avenue of promotion, not restricting the field. That was restricting the field of eligibility. And here it is not restricting the field, but by calling for volunteers like LDC. Here, right hand side, right hand column, it says normal selection without seniority marks. Panel to be formed as per merit. This is B.
Yes.
In paragraph A, seniority is the main criteria. In para B, seniority marks is not to be considered. Merit is the only criteria. Now C. This is also 25% promotion, para B.
What do you mean by not restricting the field?
My lord, here field is it may be in a wide range. Here it is only limited to Howrah division. It may be open invitation of application, but they must be diploma holder.
Yes.
Here it was not. In page 14, your lordship will find
Page
14. What is their educational office should directly fill up the must have passed ITI, apprentice, or 10 plus 10 science stream. Page 14.
Page?
Page 14, that is the serial number 3.
Yes.
Must have passed ITI.
All right, you proceed next. Next, which
Yes.
point you want?
Restricted.
No, you place on your own field.
Now, my lord, B I have placed before your lordship. C. Here it is the post. C is general selection post.
We understood that. Now
no,
come to the next point.
Yeah, no. C I shall explain before your lordship.
Yes.
A and B is restricted to 25% promotional quota. And C
Yes.
C is general selection post. Selection to post in which the volunteers are called across cadres, departments without restriction of field and all eligible candidates called for selection. It is absolutely unrestricted. Here, my lord, the right hand side, selection without seniority marks, panel to be arranged as per merit.
Yes.
So, in general selection, panel is to be prepared as per merit and it's the open selection.
Now, what did the tribunal say?
Tribunal say no, according on the basis of their submission, para 3, your lordship kindly page 20, para 3 of the judgment, para 3 of the judgment.
Yes.
And herein drawing our attention to the board circular dated such and such, learned counsel for the applicant would urge that selection should be termed as a general selection. In pleadings, the applicant.
We don't repeat. We have got that point, Mr. Bhattacharya.
Yes.
Come to the next point.
Yes. So here, this is the only criteria.
Very good. Anything else you have to show? You have anything else to show, Mr. Bhattacharya?
Yes. From this, the learned tribunal has deviated.
Show us that portion.
Yes. This is general selection. And
yes, come after recess. Oh.
Well, after recess, I am in a difficult position. I am in a little difficult situation, my lord. Anyway, Mr. Putting it there.
Then we keep it after vacation,
No,
Mr. Raju.
the principal respondent is.
No, we will hear him. If you are not there,
yes,
we can hear it. Then we will hear it after vacation.
My lord. My lord, let him continue.
No, we want to finish it off, Mr.
Yes,
Raju.
my lord. It is their urgency, my lord. The entire panel is stuck up and so and so. I said, demonstrate. I am a second highest marks candidate in this.
We have seen that.
না না তুই
Kindly,
কি ফটিকের কি প্রবলেম কি
no
আফটার
problem, I shall do this one.
আফটার রিসেস
Yes.
Then you come tomorrow.
let it continue
Tomorrow
After recess.
after recess, we have a 2 p.m. fixed matter, Mr. Ramesh.
so if it is tomorrow then it is at 2 p.m. my lord.
Tomorrow 2 p.m. we have another matter.
After 2 p.m. matter, lordship kindly be taken up.
We cannot assure Mr. Das, that is the problem. To hear it and pass orders, we have fixed it yesterday. So let it be in the list. Let us see tomorrow how it is placed. Listed থাকুক তো।
আজ আর হচ্ছে না
My lord, will you lordship please to pass an order, short order?
হার্ড ইন পার্ট বলুন
Then we keep it on after decision.
Yeah.
Had the learned advocates appearing from
Yes.
the respective parties. List the matter for further education.
Subject to your lordship's convenience, my lord.
3-4-5 তারিখ বোধহয় দুটোর সময় আছে।
Day after tomorrow করুন।
4 তারিখের fixed ছিল 9 তারিখ।
14 তারিখ।
তো বিয়ে কি? 9 তারিখ হয়? 9th?
কালকে
কবে দেখো 8 তারিখ? হ্যাঁ 8 তারিখ। On 8th January as fixed at 2 p.m.
Oh, today my lord hard and today hard.
No, we closed our year.
otherwise it will not be beneficial for it
My lord,
may I miss?
useless. Deep useless.
always it will not be
Very urgent matter.
Thursday, Mr. এই শুনুন। Thursday we will hear it, yes.
Has done 2 p.m. 2 p.m. I said.
Thursday mentioning time mention.
Not in this matter, I'm late, my Mr. DND. He's
He
coming,
is
my
not here.
He's coming, my lord. He's coming, my lord. শুরু করে দাও।
Where is the judgment you are?
My lord, আরেকটা 3টে জাজমেন্ট দিচ্ছ? আরেকটা কি গো? আচ্ছা। My lord, first is 2007-11 SCC 632. October. Uh-huh. Yes.
I will copy that. Yes, Mr. Roy, what is your submission? Tell us.
Lord, on the last occasion, Lord, certain citations were handed over to your lordship, which are not applicable. Today, if your lordship kindly see the citation,
No, as regards the facts, what do you have to say?
well, the promotion was given with retrospective effect.
Yes.
Now, Lord, he is claiming the arrear. Lord, my submission would be this, Lord, that arrear cannot be paid because on the basis of principle of no work, no pay, no arrear can be given. And Lord,
But that has been negated in the judgment cited by Mr. Sen.
Lord, kindly see the judgment which I have handed up right now through my junior, 2007-11 SCC.
2000?
7-11 SCC. Paragraph 5.
7-11 SCC.
Page 632. So this is Lord, possibly Lord, pat on the point, subject to appreciation by your lordship, Lord.
Yes, which paragraph?
Paragraph 5. It starts from first page bottom. We have heard learned counsel for the parties. It was argued by learned counsel for the respondent that when a retrospective promotion is given to an incumbent, normally he is entitled to all benefits flowing therefrom. However, this court in state of Haryana versus O.P. Gupta and followed in A.K. Soumini versus state of Travancore has taken the view that even in case of a notional promotion from retrospective date, it cannot entitle the employee to arrears of salary as the incumbent has not worked in the promotional post. These decisions relied on the principle of no work, no pay. The learned division bench in the impugned judgment has placed reliance on state of Andhra Pradesh versus KVL Narasimha Rao. In our view, the High Court did not examine that case in detail. In fact, in the said judgment, the view taken by the High Court of grant of salary was set aside by this court. Therefore, we are of the view that in the light of the consistent view taken by this court in the above mentioned cases, arrears of salary cannot be granted to the respondent in view of the principle of no work, no pay.
This was negated in the earlier judgment, which has been cited by Mr. Sen.
This was possibly not considered, Lord.
No, this principle that you deny by no work, no pay, that is also there in the judgment which he has annexed to the application. You must have gone through it. That is at page 73, you will find. Kindly come to page 75.
No, no, okay.
No, then.
Page 75, 6 lines from the top. This court in that case held on principle of, got it?
Yes, yes, my lord. That is there, but my lord, this decision has not been considered.
How can it be considered? Because this is of a much earlier period. Your decision is of
2007.
Yes, 2006.
This is 2006. Similar is 2006. This judgment also not considered by the subsequent judge.
Now, my lord, thing is this, my lord, the consistent view of the Honorable Apex Court is this, my lord, that even if there was a fault, even if there was injustice meted out to the petitioner, since my lord, he did not function, he did not work in the post which was given to him retrospectively, my lord, he cannot claim the salary because he did not work. Now, my lord, your lordship is aware of the...
Who could not work due to your lordship.
That's correct, my lord. That's correct. He could not work, but he did not perform. He could not perform due to our laches. But he was given the promotion when it was detected that he was entitled to promotion. That was given with retrospective effect. But since he did not discharge the duties in the promotional post, he could not possibly claim the arrear salary.
Yes.
Now, this is a consistent view. I have cited two other judgments.
Yes.
That is 1996 7 SCC 533. Paragraph 6 and 9. And another judgment, 2003 7 SCC, page.
Yeah, just a moment.
Hmm.
2003, volume 7.
Yes, ma'am. Paragraph 9, your lordship sees that that is also on the basis of the principle no work, no pay.
You're showing 1996.
Yes.
Not 2000. 1996.
1996 OP Gupta. OP Gupta was considered in the earlier judgment.
Yes, yes. 2003 7 HCC 238, paragraph 9. And in other বারো নম্বর কোডটা একবার দেখে নি কত চলছে 16 আছে ওখানে চট করে দেখে আয়।
Anything else?
No, my lord, these are the three decisions, and your lordship is aware, my lord. Yesterday, my junior handed up one decision regarding, my lord, the claim of arrears when a person was dismissed from service, subsequently reinstated. Now, my lord, here, there also the principle enunciated by the Honorable Apex Court was this, my lord, that when reinstatement is made after setting aside the order of dismissal in connection with the departmental proceeding, Lord, the non-employment, if he claims the area, non-employment certificate is to be produced. So, Lord, non-employment certificate and no work, no pay. Otherwise, Lord, area cannot.
Your answer to the judgment cited by Mr. Sen.
Lord, that is factually distinguishable for the reason, Lord, that Lord, here the promotion was firstly denied. Thereafter, errors were detected and promotion was given with retrospective effect. But area benefit was not given because he did not work. So, Lord, the case which has been cited by my learned friend, Lord, that is actually, Lord, standing on a different footing.
No,
Lord,
because the tenor of the judgment is that you cannot throw out the order of a court on the basis of a legislation. You cannot carve the jurisdiction of the court. That was the issue, and then the court said that the back wages has to be paid.
And Lord, in many other cases, your lordship has been.
Mr. Sen, anything else?
Only thing, my lord, I relied upon paragraph 32 and 31. And your lordship just fell from your lordship paragraph regarding 31. So, my lord, that there is no answer to that because it has been clearly, my lord, ratio laid down. There is no answer to that, my lord. And the three judgment, my lord.
Yes.
In the judgment, my lord, my learned friend cited in 2000.
That no work, no way principle was considered here.
No work, no pay. Same. No work, no pay considered. Therefore, but the carved out eventualities, which was considered in 2007 case that I have produced, relied upon, that has not been considered in all these cases. Exception. That has not been considered at all. And there is no reply also to that.
What is your explanation to this fact that your first you came to the tribunal said communicate him the adverse remarks.
Uncommunicated adverse remark basis. I was
stated that I communicated. And
then
thereafter also they did not give you anything. That is why you approached the tribunal again.
Again, second time.
Challenging the order, refusing.
15/3/2000. Yes.
Now that order was rejected in 15th of March 2010.
15th
that
of
is
March
page
2010.
46 of your application.
No. 15th of March 2010 was challenged in, my lord, second. Yes. Right.
No.
15th of March 2010 was issued pursuant to the order of the first way. Then it was challenged in the second way.
Right.
In the second way, direction was given to consider and give promotion with all consequential benefits.
That is page 55.
That is page 55.
Challenging the order of 15th March. 15th March 2010 order was challenged in the original application at page 51. That is 51. The fact. 50.
Yes.
That is the fact.
That is the fact.
Now the tribunal passed an order in 2012.
Yes.
Asking them to give you promotion from the junior state with all consequential.
With all consequential.
In response to that, order was passed on 5th October 2012.
5th October 2012.
Then what did you do for 4 years thereafter? You accepted the avenue. You accepted the relief. You raised an objection.
I'm telling you, Lordship. My lord, order was passed in the second way. In the second way, order was passed on 26/6/2012.
26/6/2012.
At page 55. Starts from page 50 at page 55. 26/6/2012.
No.
Yes, my lord. Yes.
Ordered by the tribunal.
Yes.
We are not
Order,
on
I am telling you, sir. I am giving the sequences. Order in the second way.
No, second. Here the order was challenged 15th March.
In the second way, order was passed on, my lord, 26th of June 2012.
Exactly.
This is the sequence. Then, my lord, I have challenged it.
You
In the-
challenged it in 2016.
Right. I'm telling you, lordship.
And prior to that, you gave an advocate's notice at
Yes.
page 57.
Yes.
What is the date of that advocate's notice?
Advocate's notice.
First page is missing. Huh? 4th of February.
4th of December 2012.
4th of December 12. Yes.
November 2013.
Then from
4th of December 2012, then November 2014, page 61.
page 61.
Yes.
No.
Yes, madam. Page 61.
61 is 14 November 2000.
14 November 2014. 14 November 2012. Not so indefinite, longish, not so
I
longish.
understand your anxiety, Mr. Sen.
My lord.
But judgment. Anyway, it's okay. The present writ petition has been preferred, challenging the order dated 29th May 2023, passed by the learned tribunal in the original application being OA 350/00968/2016. Mr. Shorn of unnecessary details, the facts are that the petition was initially absorbed in a group in Group D category on compassionate ground to the post of gangman to the post of gangman. Shown of the facts are that seeking promotion to the post of goods driver bracketed diesel in mechanical department. Goods driver bracketed diesel and or loco pilot bracketed goods grade 2. The petitioner কি বলে? Shown of the facts that seeking
promotion to the post of goods
certain such the petitioner participated in the selection process. But he was not included in the panel. Challenging such action, the petitioner approached the learned tribunal and by an order dated 20th of July 2009, directing the respondents to communicate his ACRs chotota, which are below the benchmark, and thereafter considered the benchmark and granting an opportunity of representing against the same. Stop. Representing against the same. Stop. The authorities, the competent authority was also directed to consider the representation, and if subsequently his ACRs are upgraded, then a review selection committee should be convened to consider his case for promotion. Pursuant to the said order, the respondent number 3 passed an order on 15th of March 2010 rejecting the petitioner's claim. Aggrieved thereby, the petitioners again filed an original application being OA 2354 of 2000. Is 2010? 2010, which was disposed of by an order dated 26 June 2012. Quashing the impugned order dated 15 March 2010 and directing the author respondents to constitute the selection committee and consider the case of the petitioner for promotion to the next higher grade from the date of his junior, from the date his junior was given promotion with all consequential benefits. Pursuant to such direction, an order was passed by the competent authority granting promotion to the petitioner in the post of loco pilot bracketed goods diesel bracket close grade 2 on pro forma basis from the date of promotion of his next junior Sri M. Paparao with effect from 28 July 2004 to 8 September 2010 and on actual basis from the date of shouldering higher responsibility to the concerned post from 9 September 2010. Aggrieved by the decision towards grant of promotion on pro forma basis for the period from 28 July 2004 till 8 September 2010, the petitioner submitted several representations, and as the same were not considered, the petitioner preferred an original application claiming actual being OA number
968 of 2016.
being OA 350/, একদম ফার্স্ট প্যারাগ্রাফে যে আছে, preferred an original claiming actual benefits pertaining to the said period from 28 July 2004 to 8 September 2010. The said original application was dismissed by the learned tribunal. Said original application was dismissed by the order impugning the present writ petition. Mr. Sen, learned advocate, appearing for the petitioner argues that it is due to the fault on the part of the respondents, the petitioner could not join the promoted post on 28 July 2004. And as such, it was 20. Stop. No latches are attributable to the petitioner. No latches was attributable to the petitioner, and in consonance with the direction given by the learned tribunal, quote unquote, to grant quote unquote all consequential benefits, the learned tribunal are in law in rejecting the petitioner's claim. কি লিখলে লাইনটা একটু বলবে?
No latches are attributable to the petitioner and in consonance with the direction given by the learned tribunal within quotation to grant all consequential benefits, unquote.
Comma, the respondents are in law in withholding the said consequential benefits. Such issue, comma, as urged before the learned tribunal, such on the said issue, comma, as urged, comma, no finding was returned by the learned tribunal, and such infirmity warrants interference of this court. He argues that in application of the principle of quote unquote no work, no pay, the respondents could not have denied the actual consequential benefits of promotion to the concerned post with effect from 28 July 2004. Such issue was considered by the Honorable Supreme Court. Such issue came up for consideration in the case of the Commissioner, Karnataka Housing Board versus C. Muddaiah, MUDDAIAH, reported in AIR 2007, Supreme Court 3100. And the court laid down the principle that the direction of the competent court towards disbursement of benefits cannot be curtailed by citing any circular of the government, and that the person who was willing to work but was illegally and unlawfully not allowed to do so, comma, the authorities are bound to grant the consequential benefits, considering, comma, as if he had worked. Stop. According to Mr. Sen, the judgment delivered in the case of Tarsem Lal Judgment delivered in the case of Union of India and another versus Tarshem Lal and others, comma, upon which reliance was placed by the learned tribunal, comma, is distinguishable on facts, and the same was 2008 में किया ना? This came later or Tarshem Lal was
2006.
কি লিখলে?
According to Mr. Sen, the judgment delivered in the case of Union of India and versus Tassim and others, upon which reliance was placed by the tribunal, is
distinguishable on facts. Distinguishable on facts. And that even if was distinguishable on facts, and even if there are two contradictory judgments on similar issues, it is incumbent upon the court to accept the view, even in the case of to accept the view that this court would be governed by the latter decision. In support of such argument, reliance has been placed in the case of Bholanath Karmakar and others versus Madan Mohan Karmakar and others, reported in AIR 1988, Calcutta 1.
And which was more reasonable, that was.
As the same as evidently the latter judgment is more reasonable. No, that should be more reasonable. That is your, anyway, you want that argument to remain.
has been stated in the
More so, stop. Per contra, Mr. Roy Learned Advocate appearing for the respondent submits that admittedly the petitioner did not work in the promotional post for the period from 28th July 2004 till 8th of September 2004. Even if the delay has occurred due to any administrative error, even if the delay is occurred due to any administrative error, the petitioner cannot be granted the actual benefits, in application of the principle of no work, no pay. Stop. He further argues that there was no deliberate intent on the part of the respondents to deny the petitioner's benefits, and no mala fide can be, and there was no mala fide in such decision of the respondents. In the decision of the respondents. Stop. The petitioner has also not been the petitioner was granted the benefits by the order dated 5th October 2012, which he accepted without prejudice, which he accepted without any objection, and subsequently submitted representations re-agitating the issue, alleging that he had been denied the actual benefits of promotion from 28th of July 2004. In support of his arguments, reliance has been placed upon the judgments delivered in the cases of 18th DHF, 96 volume 7 SCC 533, 2007 volume 3, 2003 volume 7 SCC 238.
Only
and 2000.
The 2003 Lord, is a three-judge bench decision. Lord.
Yes. 3 volume 7 SCC, প্রথমে 96 ভলিউম 7, তারপর 3 ভলিউম 7, তারপর দেবে 2007 ভলিউম 11 SCC। এই তিনটে আর এই তিনটে তোমার পিটিশনার পেন ড্রাইভে পাঠিও আমাকে প্রিন্ট আউট স্টপ। Hardly learned advocates appearing for the respective parties and considered the materials on record. Indisputably, the petitioner was working under the railways, and the provisions of the IREM are applicable to him. In the case of Tarshan Lal Supra, the issue which came up for consideration, it appears that Tarshan Lal Supra, the issue which came up for consideration was as to whether, in view of para 228 of IREM, the petitioner therein could have been allowed the benefits of pay from the date of could have been given the areas pertaining to the period he did not actually shoulder the duties and responsibilities to the higher post. Stop. The Honorable Supreme Court in the said judgment, it was decided that in view of the service conditions, the petitioners cannot be granted the actual benefits pertaining to the period during which he did not render service in the concerned post. Stop. The next para. It is well settled. No, Tarshem Lal bolecho na? Stop. It is well settled. It is well settled that a decision is an authority for what it decides, and not what can logically be deduced therefrom. Even a slight distinction in fact or an additional fact may make a lot of difference in the decision-making process. Stop. The judgment is a precedent for the issue of law that is raised and decided, and not observations made in the facts of any particular case. Stop. In the present case, the petitioner's service conditions, in the present case, the petitioner was guided by the provisions of what is IREM? It is
Indian Railway Establishment Manual.
Provisions of Indian Railway Establishment Manual, which provides a clause to the effect that a person, that an employee cannot claim the areas pertaining to post in which he has pertaining to the post in which he had not actually shouldered the duties and responsibilities. And in view thereof, the judgment delivered in the case of C. Muthaiya is distinguishable on facts. Stop. The learned tribunal. The learned tribunal in our opinion, rightly observed that as per the rules in vogue, payment of arrears of pay for the period during which the employee has not held the promotional post is not to be treated as a consequential benefit of a promotion effected from a retrospective date. Stop. The learned tribunal, upon dealing with the factual issues, had arrived at specific findings, and we do not find any patent error of law in the same. Stop. The order also does not suffer from any jurisdictional error or any manifest injustice warranting interference of this court. For the reasons discussed above, the writ petition is dismissed. There shall, however, be no order as to cause urgent certified xerox code. Sorry, Mr. Sen, you argued.
Paragraph 32, it has been said, ratio led to paragraph 32, if I may. Well, although it is a post-mortem already judgment delivered, it said
No, in
that
appropriate cases.
yes, in appropriate cases. Appropriate cases.
It's the sentence starts with in appropriate cases. That is, it is dependent upon the facts. There is no denial of this proposition that the person, if for their laches you have not come, or if there is a legislative provision which you are citing for the purpose of denial of benefit, you cannot you cannot deny them the benefits. In our understanding, that is the principle, and it is applicable as per the facts of the case. Sorry, Mr. Seth. Yes, next.
Item number 17.
Grateful.
My lord, in 17. Yes. Yes. Yes, Mr. Sen.
Yeah, grateful, Rosh.
Opposition. Opposition. আপনাদের দিয়েছি ওখানে ফাইল speaking person is not compliant or to do not cheat. What do you do? He was very good experience. But I passed an order in police.
My lord, I
Item
beg to
19.
appear on behalf of 17. Beg to appear on behalf of the respondent, my lord.
Yes, Mr. Dotto.
My lord, today I am filing my opposition, which has been served on my learned friend.
Yes, my lord. It has been received by me, learned advocate Mr. Sudeep Sarkar, my lord, 7th, 12th.
You have not used your reply.
Yes, my lord. 1 week time may be granted, my lord, to file the reply.
Mr. Dotto, learned advocate appearing for the respondents, files the affidavit in opposition.
Sudeep Sarkar.
Stop. Let the same be kept on record. Stop, Mr. The learned advocate appearing for the petitioner.
Sudip Sarkar, my lord.
You are
I am Lavanyamay Sarkar, my lord.
But Mr.
Sudip Sarkar is
Sarkar.
appearing. He is engaged in court number
very good. Give your name. Give your
Yes,
name.
Lavanyamay Sarkar.
ওই একই সরকার Mr. Sarkar press for extension of time to file the affidavit in reply. When did you get the copy?
7th December, my lord. 7 December 2023.
Mr. Sarkar, learned advocate appearing for the petitioner submits that a copy of the affidavit in opposition was belatedly served upon the petitioner and as such press for extension of time to file the affidavit in reply. Stop. Such prayer is considered and allowed. Let such affidavit in reply be filed within a week after the vacation. Stop. List the matter for further consideration in the daily supplementary list of this court on 17th January. Yes.
Lord,
next.
one more thing, my lord. My lord, the private respondent was not appearing in the matter. My lord was pleased to direct me to serve them the address of the private respondent so that that can be served, my lord. So that has been served a day after, only after the order. It was served on 9/10. It was heard, my lord, and I supplied it on 11/10. That the private respondent.
So he's a retired person.
No, my lord. It is a case of compassionate atonement, wherein the petitioner did not get the job, the private respondent got the job. So the private respondent was made a party.
So
now,
you, you have given the address of Mithurai to
him,
Mr.
my lord,
Sarkar.
2 days, within 2 days. It has been served, my lord, on exactly, my lord.
No,
it was
that's
served
okay.
on 13th.
Served upon her.
Yes, on 13th.
Have you served upon her? Mr.
So, my lord, that we completed, my lord, by them.
To furnish. আচ্ছা একটা লিখে দাও.
My lord, we have furnished.
Mr. Dotto further submits that pursuant to the earlier direction of this court.
ছবি তুলে নিন না এটা একটা কপি আছে এটা ছবি তুলে নিন
The respondent number, the respondents have furnished the address.
আচ্ছা ঠিক আছে এটা ছবিটা
তুলে নিন
Has furnished the present address of the respondent number 5 to the petitioner.
To the petitioner advocate.
To the petitioner's learned advocate. Have you sent the letter?
But actually, my lord, it is beyond my knowledge, my lord. Sudip Sarkar is appearing, my lord. I asked him.
As no one appears today on behalf of the private respondent. No, if she has not been served, how can we say?
Yes, ma'am.
লিখে দাও. No one appears today.
Let them take this.
Served করে, you have served.
My lord, I have served. I have given the information as to the details address of the respondent number 5. Now, my lord was pleased to direct them to serve on the petitioner to serve him.
এখানে রেখে
একটা কপি
no one appears টা কেটে দাও, কেটে লেখো the petitioner is directed to communicate this order to the respondent number 5 and to file an affidavit of service on the
day. Much of
17 January, ne?
17. Much of.
Get full. Okay.
Yes, we are for the petitions.
But I'm for the respondent.
May I please your lordship, my lord. Here is a burning case of deprivation as well as discrimination, my lord. Burning case, my lord, since the top, my lord, since 1998, my lord. The cause of action actually arose with effect from 1st of August 1998. And the casual laborer, my lord, he is so sure of his success, my lord, he is keeping his fight, my lord, continuing. He is keeping his fighting against the DOT, that is the Directorate of Telecommunications, my lord, continuing for such a long time, my lord. My lord kindly says, my lord, this is a matter, my lord, merely, my lord, for regularization of the casual laborers, my lord.
I am appearing for the BSNL authorities. They are appearing for the DOT, Department of Telecommunication.
I have served upon all the respondents, my lord.
মামলাটা কবে রাখলাম আমরা? এই ছেলেটার ওই যে সুকুলের ওই যে বললাম না, এই যে টিফিনের, এই যে রিসেসের আগে করলাম না, দুটো ম্যাটার ছিল। ওই যে 16ই জানুয়ারি রেখেছি বোধহয়। না 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 না, not 8 না। ওই যে দুটো পরপর ছিল যে, ওই মুখার্জি অ্যাপিয়ার। আচ্ছা কোনটা রেখেছি 16 জানুয়ারি দেখো তো। Sir, we keep it
Yes,
on,
my lord.
we keep it on 17th January. Similar matter is coming up to us before that date, so far as we remember.
As your lordship.
For BSNL matters, my lord, BSNL and DOT matters, my lord.
No, it
See,
was regarding
in the-
regularization pertaining to the railways here, but we will consider your case almost there.
Only one thing, my lord, they filed one writ application before this Honorable High Court
Alright,
in the year 2011.
that is not maintained.
No, thereafter it went as TA, transfer application there. They lost it in 2011. Thereafter, in 2016, they have filed another application, original application. That was dismissed and they filed one review application. This review application, the dismissal of the review application, they have come against that order and before your lordship, my lord. They are saying that casual laborers, we are saying that they have not worked for coming under the scheme of temporary status. They are covered by 1998 scheme. In that scheme,
They have not challenged the parent order. Review application was dismissed.
Yes.
So both the orders must have been
Yes.
challenged. Then
So in that, my lord,
Decide that,
they are trying to come under a scheme. In that scheme, we have specifically stated that they did not work for that period for which they are entitled to that scheme.
That is a
Benefits
matter
the
of
scheme.
fact. That is-
So I think those two matters would be different, my lord. So if your lordship takes up any other day, subject to your lordship's convenience,
very good. It
Yes.
let it appear on the supplementary list on
my
that
lord,
day.
as your lordship.
Even if it is not serious, because this is a hearing matter.
Yes, my lord,
Paperwork
absolutely.
has been prepared. We are
Yes.
taking review application. You have annexed. Have you annexed the review application?
Yes, yes. Review application, nahi, review order ta ache.
Original
order has been annexed, my
No,
lord.
no. You bring your review application.
Original application has been annexed. Reply has been annexed. Thereafter, the order.
Review. You have filed any opposition?
No, my lord. No. It was generally in tribunal, my lord, review is taken up and then decided.
All right. In this original application, reply rejoinder
Yes,
is
yes,
there.
yes.
But the order has been passed in the review application.
Yes.
Is that on record? Review
I
application.
am, my lord, just, my lord, challenging the very order, my lord, that was passed in the year 1916, my lord, the original order passed in the transfer application, my lord.
Very good.
Yes, my lord.
Against
I
that-
am not going into the
But
into
we
the
want to see your review application.
Ah.
That is a part of these proceedings.
maybe, my lord, but my lord, we
In that
the
case, my lord,
review
they can file one
application, my lord,
supplementary
I am
affidavit
not going
annexing
to
all the
place
documents.
the review application.
We are asking him to place the same before us.
My lord,
on the
as
next.
your lordship.
What is the number of the review application?
Review application, my lord, RA
Last.
RA 350/11/2016.
Where do you get it, Mr. Panda?
Page 110, my lord.
Mr. Haldar Learned Advocate appearing for the petitioner is directed to place before us the review application being RA 350/11/216 on the next date of hearing. Is the matter for further consideration in the daily supplementary list of this court on 16th বললাম উপরে এভিডেভিট অফ
17th
সার্ভিস 16 তারিখ এটা কি আগে ছিল এভিডেভিট অফ সার্ভিস না আজকে এভিডেভিট অফ সার্ভিস ফাইল বাই দি and Mr. Panda you also check up if you have used any independent reply.
I shall.
Yes.
Well, let Mr. Dhiraj Trivedi's name be recorded. He is appearing for the Union of India.
India.
Point number 1,
দিয়ে দাও না। Is he in court?
He is in court.
ওর নামটা দিয়ে দিও তো।
বলে দিয়েছি।
Yes, next.
Yes, come back.
We have kept him. We have
I
kept.
apologize, Millard. I was on my leg.
No, we have noted your running scene. Yes.
My lord, item number 19, my lord, and for the writ petition, my lord.
Time খেও না বাবা, time খেও না। Why you are seeking adjournment?
Petitioner is that side.
What is the, you are the petitioner?
My lord.
Tell us now, what is the story? Let us hear the story.
My lord, I'm not prepared, my lord.
You are, who is your senior?
My lord, Mr. Ritobrato.
Where is Ritobrato Mitra? Huh? Sitting in his chamber, Bird Library. Huh?
My lord, can you take up the matter after vacation, my lord?
On the prayer of the petitioner, the matter stands adjourned. You are there, Mr. Dev, for the.
Yes.
Please, the
No, matter
matter
was taken up by your lordship on the other day also.
for final hearing in the combined monthly list of January 2020.
Yeah, for final hearing. Ceremony
It's not possible.
আমি তো petitioner, কিন্তু আমার তো দিয়েছে opposition দুদিন আগে দিয়েছে।
Now, from 2028 onwards, all division benches will be headed by services. You are the exception. You will be there in one of
Kumu আছে এটাতে না?
কটাও তো আছে। কটা তো আছে।
20
Yes, Mr. Gupta.
My lord,
I appear for the respondents, still authority.
my lord, for the
My learned friend is appearing for the
petitioner,
petitioner.
my lord, only last.
For the petitioner?
My lord, only last question, Mr. Mojumdar appear, my lord. Lordship was kind enough to create the matter to appear today, my lord, and opposition is filed by the my lord respondent, my lord. My lord, I have been served with the copy on this Friday, my lord.
What? Opposition?
Opposition, my lord. Kindly, my lord, allow me.
Then you had the weekend. What did you do?
My lord, I have already talked to my.
You had the weekend. What did you do?
Instruction. I am unable to receive.
Mr. Gupta can complete the pleadings by 1 week. You are a young man. You are having that holiday. Why didn't you do it?
No, no, my lord.
My lord, that is personal to the next matter, 21. My lord, 20 and 21 were stacked together. One is for the executives, my lord, retired executives of SAIL, and another, my lord, for non-executives. For 21, my lord, my reply is ready, my lord, to file.
Or in 20, order koro.
Lord, may I file the affidavits in both the matters?
Acha, Mr. Mr. Gupta, learned advocate, appearing for which Mr.
Sale, my lord, sale.
5. 225, na?
My 225, 225.
Mr. Gupta, learned advocate, appearing for the respondent numbers 225, files the affidavit in opposition. Stop. Let the same be kept on record. Stop. Mr. Chakraborty, learned advocate, appearing for the petitioners. Press for extension of time to file the affidavit in reply. Stop. Let such prayer is considered and allowed. Stop.
My
Let
lord,
such
may I draw-
affidavit in
may I draw
reply
my lord's
be filed
kind-
within.
My lord, attention, my lord, on the 19, they have already filed challenging this same order. They have already filed a writ petition 19, my lord.
19th is
This is
returnable.
item number
20.
20. Let us finish it up then. 19 is another matter.
No, no, 19th, coming 19th, my lord.
19th
My
of
lord,
December.
SAIL has filed challenging the same judgment, another writ
The
petition
same
which is
judgment of the
returnable on
tribunal.
19th of
We
December.
will keep it along with this.
My lord.
You remember the date when we are keeping.
এই তুমি আমাদের নম্বর দিতে হবে তাহলে।
Then why you are
19 যেটা।
saying item number on 19th December?
19th
it has
December.
been kept.
19th December, my lord, that writ petition is returnable which was filed by SAIL.
Very good. You will keep it for রেখে দিই। কি বলেছে? Within a week after the vacation, list the matter for further consideration on 18th January করে দাও। পরেরটাতে item 20 who
My
is
lord,
for the
item
petitioner.
21, I am for the petitioner led by Mr. Mojumdar. May I file my affidavit in reply, my lord?
ও তোমার রিপ্লাই হয়ে গেছে? হ্যাঁ। আমাদের দিয়ে দিয়েছো কপি?
হ্যাঁ, দিয়েছি। The learned advocate appearing for the petitioner files the your opposition is on record
Opposition is on record. I filed it today.
today.
Yes.
এই তাহলে পরেরটা দাও, এটা তো item 19 20 কোনটায় অর্ডারটা নিলে প্রথম
পুলিন।
তো 21 ফাইলটা দাও একটু। তো 21 টাতেও মিস্টার গুপ্ত ইয়ার ফর 2 to 5.
Lordship.
Mr. Gupta learned advocate let the affidavit এরম ভালো let the affidavits exchanged by the parties be kept on record. Stop. List the matter for further consideration. Stop. A similar matter has been fixed for hearing on 21st of when did we keep it? 18th January.
18th January.
18th January. In view thereof, comma, list the matter for further consideration on
Along with that.
18th. Not along with, separate application. It will be there in the list. বুঝেছো? Analogous হবে না, পরপর দুটো দিয়ে দেবে। Yes. A few days ago.
They appear on the tribune by
Not sure. He was one of them was very proactive person to see that matters. One could not be conducted. In previous one of them. You have not met. How was your experience with job? You find it found it interesting.
kind of same order.
Stereotype. Whether you give a DPS bail or
The person that they are how long?
yes. This is the question.
What is the state of the trial? How many witnesses have? And then
especially in bail matters.
ডিনাই করবে না ছুটির পরে এটি পরে বলুন।
No, Joy had a very good practice in business. So he understands the practice and he had predominantly handled criminal cases. So he is excellent in Tapabrata conservative. That becomes difficult. How many times you will keep quiet? One day or the other you will burst. Yes, Mr.
My lord,
Chakraborty.
in 22, I appear on behalf of the appellant, my lord.
Very good. Your good case or bad case?
Very good case.
Very good case. Chalo, compassionate appointment.
No.
My lord,
The-
I am happy on behalf of Anirban Mitra for the Union of India. So, my lord, I am paying for.
It is disciplinary proceeding.
Yes.
Huh?
Yes. He was removed from service for no fault of him. And on the same cause of allegation, 11 DSP personnel were implicated in a criminal case. Subsequently,
I am paying for not this week.
We come tomorrow, Mr. Chakraborty. You will be there.
Okay. কালকে আসবেন?
In most of the hearing matters which we have fixed, since the vacation is coming, the advocates are not found. Years are sent and kindly adjourn.
My lord, this is my responsibility. That is why from the very beginning, I am before my lord. This is my responsibility. I am answerable.
Hopefully you won't be taking adjournment tomorrow.
No, my lord, I am paying for not this week.
Not?
Not this week.
No, let it be in the list. Let us see how it proceeds.
Tomorrow. Tomorrow.
It will be there in the list. If it is taken up, we will take up.
Okay,
No, you once time will come when we find that you conscious. Okay. Time will come. Yes.
Yes, I'm for the respondent.
Where were you in the morning? Another matter was called.
My lord, another matter, I am on the leaks, my lord, in another court, my lord, that was.
Well, on last occasion, 19th October 2023, the lordship was pleased to pass an interim order till 15 December 2023. Lordship order is 19th October 2023. Second page. It appears that the charges leveled against the appellant are grave, and in the impugned charge sheet, it has inter alia been observed that the appellant had connived towards submission of the crime and that the reputation of the force had been tarnished due to his acts. In the said conspectus, prima facie and arguable case has been made out by the appellant.
Yes. Mr. Hosh, you have this was at the interim stage.
Yes.
No, the tribunal.
My lord, the learned judge, my lord, passed the order for direction of affidavit, but no interim order was passed. Refusal against the interim order, my lord, this appeal was preferred.
Yes, place your case. The writ petition is not yet disposed of. It is pending.
Pending.
So what do you
And
say?
no opposition has yet been filed.
Because, my lord, that appeal in the meantime, immediately thereafter, they have filed the appeal.
What do you say about this interim order? Do you want to use any opposition and contest the same, or we
Yes,
will
my
send
lord.
it to
Definitely.
we will send it to the
Definitely.
trial judge for hearing of
Yes.
the final,
Yes.
and we continue the interim order till
My lord, kindly consider out of 12 witness.
that is why we are asking.
Yes,
Then
my
you
lord.
have to
Out
come
of
up with
12 witness already, my lord, cross-examination of 11 witness already held. And thereafter, my lord, your lordship was pleased to pass this interim order, my lord. My lord, kindly see.
all right, then let him place his case. Place your case.
Lordship, kindly come to charge sheet. Page 22 of my stay application. The charge is page 23. My lord, I am reading one by one the charges. How the disciplinary authority, the capsule mind of the disciplinary authority is apparent on the face of the record. At the time of, my lord, issuance of the charge sheet, he has confirmed conclusion about the guilt of the petitioner. The language, very language of the charge sheet, my lord, must be considered that he must be come to a tentative conclusion. He cannot come to a confirmed conclusion when there will be a regular inquiry. The inquiry officer is a subordinate authority. He cannot inquire the matter fairly and impartially. Lordship, I am reading, my lord. Item number 1. A case was registered at RPA Post, Azimganj, Howrah Division, by number such and such, dated such and such, under section 3A RPUB Act. In connection with the misappropriation of railway properties, theft of a number of rail line cut pieces having different sizes, values of such and such, from the jurisdiction of RPA Post Azimganj. During inquiry, Lordship kindly mark it. During inquiries of this case, Somoresh Das, Constable, petitioner before your Lordship, was found involved. This is a specific conclusion. Was found involved in this crime. The disciplinary authority at the time of framing charges came to the conclusion that I am found involved with the crime. What more inquiry officer will do? Accordingly, Sri Somoresh Das was arrested by inquiry officer Sri Rajat Ranjan, and consequently on the very day he was produced before the Hon'ble Court, where he was enlarged on bail on the same day by the order of the Hon'ble Court. Somoresh Das' involvement in the above incident was spread in public domains, for which the image and reputation of the force has tarnished around all departments of railway, which fully tarnish the image and reputation of the force. Had already concluded the matter. Secondly, your lordships, next second charge. As per statement dated such and such, Gautam Mondal, supervisor of railway contractor of AB Construction, Shri Somoresh Das, Azimganj, in regular touch with Gautam Mondal, and all the information regarding cutting and loading of rail line carried out in different days were given to him by Gautam Mondal. He was also facilitated by payment by Gautam Mondal and each trips of the disposal of the stolen material. Apart from the CDR explained that he taught Gautam Mondal, the prime arrestee, 103 times from such and such date. Which certainly, kindly mark it, which certainly indicate his connivance. Which certainly indicate his connivance in the above organization. So if the charge is proved by the disciplinary authority, my connivance if it's proved by the disciplinary authority at the time of framing charges, then what more disciplinary inquiry officer will
Right,
do?
don't repeat that repeatedly.
Then you lost kindly again 3. Being a member of the force, Somoresh Das connived with accused, outsider and railway employee to steal ferrous railway materials from different locations of Azimganj Post jurisdiction. Basulitola, Railgate, number such and such, and Gosaigram Railway during the month of such and such for his personal gain. Then, being a member of the force, Somoresh Das involved in this crime in connivance with dubious people and railway employee, which resulted to huge loss of railway property amounting to rupees such and such. The discreditable act on the part of the above staff and the involvement in the above organized crime
বইটা আছে
is highly objectionable. and disreputable in the discipline force. He did not care his professional obligation, being a member of the force and involved himself in the 4 years activities.
This is the imputation. Where are the charges?
This is the charge.
This is the charge. And the imputations?
Same language. Same language. Now, my lord, your lordship, can you see, against that imputation, I was asked to give reply. My lord, I submitted my reply. Lordship, can you come to my reply? Only 2 parts of my reply. Page 8, page 66. This is my reply to the charge sheet. The disciplinary authority directed me to give reply to the charge sheet. Your lordship, come to page 74.
Railway Protection Force bulletin. Railways Act.
Page 74, 5.1. That I deny and dispute each and every charges and allegation as incorporated in the memorandum of charges, as also about the criminal charges in which.
Page 64.
Page 74, 5.1.
Yes. Yes.
Now, logically come to 5.2. That it is submitted with your honor that the charge and allegation in the proposed departmental proceeding against me are same and identical as the charge of criminal case. Right number such, dated such, which I was arrested and was forwarded to London Court. And thereafter, then was not bail in the same day. That the prosecution witness in the proposed departmental proceeding are the same prosecution witness who have been relying
So
upon
before the read court, you challenge the charge sheet.
the charge sheet. 3 things I've charged. I've challenged. The charge sheet I challenged.
I think you should take some water.
My lord. No, my lord, I am slowly, my lord, I am making out slowly.
না না বলছি আপনাকে একটু জল খান আমরা কাস্টমার এসে যান
And now, let's come to 2, 3, and 4.
Where is the writ petition? Mr. Mojumdar, take some water. Where is the writ petition? Do you have the copy?
Writ petition copy. No. But entire story of the writ petition in my state application.
Very good.
Let's see. Finally come to second part of my reply. This is very important.
Yes, you challenge the charge sheet. Yes.
Now you logically come to second part of my reply.
No. What you challenge the charge sheet and what?
I challenge the charge sheet.
Notice to participate in the inquiry.
Now, my lord, second thing is this. 2 higher authorities are involved in this matter in the rank of Assistant Security Commissioner. One Assistant Security Commissioner made a preliminary inquiry, submitted a report holding not only myself guilt, holding entire witnesses, those who are annexed with the charge sheet, they are guilty with the charge.
In preliminary inquiry.
And the report of the preliminary inquiry was taken as a part of with evidence in the charge sheet, but Assistant Security Commissioner was not included in the as a prosecution witness to prove the said report of the Malad preliminary inquiry report. Second thing,
Where is that? Show us page 28.
Lordship,
The
can you come to the
documents. Where is that preliminary inquiry report? I think Mr. Mojumdar, come tomorrow. We will have it tomorrow. Come tomorrow. Get yourself freshened up and
tomorrow? Very good.
My lord, instead of 13, my lord, 14, my lord, if possible.
we can take it up after the vacation, but there is an interim order which
Yes.
naturally will oppose.
Yes, I am ready, man.
So if you want that, you can,
Yes,
we
tomorrow.
can fix a date after vacation also. The interim order will be after that date.
I am ready, man.
Very good. Then come tomorrow and argue.
বাসাটা কাছের জন্যই বলছে যে আপনারও অসুবিধা হচ্ছে ওষুধপত্রের জন্য খাচ্ছেন কিন্তু আপনার ভাগ্য করে আওয়াজ
রেলওয়ে প্রোটেকশন ফোর্সের বইটা একটু আনিয়ে নাও না, তাহলে ওই ফাইলটার সাথে আমাকে মাইলটকেও পাঠিয়ে দিও। Item.
My lord, I beg to appear on behalf of the appellant.
কি বলবো নাকি
একজন মিনিট
না না এই যে আমাদের ইয়ে ছিলেন না
সুবিধা
সুবিধা
হ্যাঁ আমি ওনার জুনিয়র
সুবিধা তোমার সঙ্গেই ছিল
হ্যাঁ।
না যেহেতু আমি সুবিধাকে বললাম ওনার এই কারণে অ্যাডজার্নমেন্ট হয়ে গেল
আচ্ছা আচ্ছা
মানে সুবিধা এই ম্যাটারে তোমার সঙ্গে সুবিধাই ছিলেন
সুবিধার সঙ্গে আমি বলে দেবো আমি
না এই কারণে তাহলে আমি ওনাকে বললাম তো সেই শুধু আমার কথাই উনি চলে গেলেন
Can you hear it? That is what I am.
কোন কোর্টে
But it was not on your ground. It was not.
পাঠিয়ে দিই ধরে নিয়ে যাবেন আমরা
এই শোনো, এইটা একটু দাও তো 25-এর। এটা 25. Let's see well. It's taking up the first it was released by Homans. Then it came out to be
সেপ্টেম্বর হয়েছিল মামলাটা তাই তো 18 সেপ্টেম্বর
কোনটি
18 সেপ্টেম্বর
18 অক্টোবর
18 অক্টোবর
ও গভর্নমেন্ট
আচ্ছা
I'm not very
plus they would have written
then you can put a heart.
তাহলে করে
হ্যাঁ এটা অন্য মামলা
What the problem is that there are two other assigned matters.
24, 25 and 26. 25 is my appeal.
Well, 25 and 26 is from one writ petition.
Please hear us. What is your... In 25-26, Mr. Bandyopadhyay, my brother was there with Honorable
Justice Bagchi.
And the matter was released. So whether my brother can hear this matter, we don't know. At some point you people
My lord, I was there.
Already
the matter,
the Honorable Division Bench, the coordinate bench released.
My lord, the matter.
Now, my lord, it has been assigned before your lord.
Here the poor fellows.
My lord, the matter, my lord,
Kindly take out this matter.
subject to correction.
Very urgent.
The matter was not released. On facts, my lord, it was not released. My lord, it was sent before the honorable regular bench. We moved in the absence of the honorable regular bench.
Sir, see the language of the order. দেখেছো? Have you read it, how the matter has been released? We are not making unnecessary statements. You find out it, a doubt came up in my mind, that is why I am sharing with you. এই অর্ডারটা দেখা ওদের
25 year old
না 25 না 26
জয়মাল্য হচ্ছে ও এটা আমাদের আমারটাই আমারটা 25 দুটোই 25 এরই কথা হচ্ছিল কি করে ওখানে যাবে আমার তো প্রথমে এলো প্রবলেম তো নয় এটা
24 নিয়ে কোনো প্রবলেম নেই 25 24
25 আর 26 তো একসাথে
So reason has been assigned, my lord, whether for
এটা তো আমি নেই আমাদের নয় এটা অন্য ম্যাটার
but my lord, with regard to 24, I have an extension to pray for, my lord. Once 24 and 25 is resolved.
Bandyopadhyay, how can we pass if we cannot?
But in 24, my prayer for extension is in 24, where no such difficulty is there.
আচ্ছা 24 টা দেখ
আমাদের বিপগুলো দাও না একটু ওখান থেকে
yes give the
Because in 24, there's a direction for filing of affidavits. Now, my lord, our predicament is that when my lord, here only the Kolkata police is a party respondent. But after the impugned order was passed, the Kolkata police, my lord, transferred all records to CID. So now and who conducted the investigation for a few days before your lordship stayed the order on 18th of October. Now, my lord, the records are all lying with CID. But the party respondent is Kolkata police, who is not having the records for the time being. My lord,
but this respondents, this Bishwajit Das and Subroto Saha, they are from the
my lord, that is Detective Department, Kolkata police, and that is by name. That is by name. But my lord,
It's your prayer,
my lord, an extension for file the affidavit in opposition to the stay application. কদিন লাগবে বল?
and by adding CID as
কদিন লাগবে বল?
no that adding business cannot be done without an application.
Application, yes. So we take
The
10 days.
contested
Let us
matter,
take
na,
10 days.
people will not agree. Now we can extend the time. You can ask your, because the order has been stayed.
My lord, kindly extend it for 10 days. My lord, I'll advise my client to come up with the appropriate application. In the meantime,
Where is the order date?
18th of October 2023.
কোথায় দেখাও না
it is not my appeal
No, it is no, but then there will be no dealing with the allegations. No, intentionally, I'm saying. Some things were said intentionally.
Just Hon'ble website.
দাঁড়া না জজ সাহেব আছেন
184
what he did was
184 ওটা জবানবন্দি করে এটা আলাদা
from the court. Which one you have released? And from the court and said, do you have
রিলিজ হবে তো কেন হবে
she said that no
আমারটা তো রিলিজ হয়েই তো এলো হবে কেন এটা তো শোনেন নিবে
উড়িষ্যা নিয়ে যেতে হবে এখানে আর হবে না
এটাও রিলিজ হয়ে যাবে
পুলিশ রিল্যাক্স করে বসো না আমরা আছি তো তোমাকে সাপোর্ট করবো
সাপোর্ট করে আছে খুব অনেক ধন্যবাদ ওরা তো কিছু রিলিজ করলে বিপদ হয়ে যাবে আর জায়গা নেই
কি বলেছে এতগুলো বেঞ্চ আছে এখন
কোনো বেঞ্চ নেই একে একে সব রিলিজ করে দিচ্ছি
বেঞ্চ বানিয়ে দেবে বানিয়ে দেবে
এরকম সেলিব্রিটি ক্লায়েন্ট নেবে একটু খারাপ লাগে
কিন্তু তোমার ক্লায়েন্টের জন্যই হচ্ছে ক্লায়েন্টের জন্য হচ্ছে না
পদ্মা ফর্মে নিয়ে চলে যাও আমরা আউট স্টেশন মামলা দেখি
এটা বাঁচবে
দেখো
শুধু ওই ব্রহ্মবাদে এখন আঁকড়ে উঠেছিল কি নাম ওই সঞ্জীব গোয়েঙ্কা শুনে
yes
but my appeal is 25
আরে মহা মুশকিল করেছে we are hearing 25
very well
24
go and sit there
I am sitting as
go
okay, I am worried about this
Mr. Bandyopadhyay, learned advocate, appearing for the
state respondents
please for extension of time to file the affidavit in opposition. Stop, such prayer is considered and allowed. Let such affidavit in opposition be filed within a week after the vacation. Stop, reply thereto if any be filed within a week thereafter. Stop, list the matter for further consideration. in the daily supplementary list of this court on 24th January. Stop.
22nd.
Eh?
No, no, matlab that week I'm in some personal difficulty, but maybe
We keep it on 29.
29.
ওরা
On
time চাইছে
29
affidavit file
January.
করতে, state.
29 January. Stop.
Affidavit
The interim order passed earlier is extended till the end of January 2024 or until further orders, whichever is earlier. ওইটা ইয়ে করে 29 January 2024 আবার 23 লিখে দিও না, তো পেছনে যেতে হবে।
Your Lordship, one indulgence. If the date can be placed after 29th, Your Lordship, sometime around 30.
People agree to a date, we will
Your
we agree
Lordship,
to a date.
Your Lordship, I apologize. 30.
30 তারিখ হবে? 30 তারিখ হবে?
হ্যাঁ করো না, না হলে অ্যাডজাস্ট করবো, কি আছে সব।
30 তারিখ।
But maybe on 30th, Mulad.
On 30th of January, stop. The interim order passed earlier is extended till the end of February 2024 or until further orders, whichever is up. Yes, এটা গেল।
সবগুলো না, এটা খালি 24 নম্বরটা হলো। 26টা বলছি
Obviously পাস করেছিলাম।
ছিল তো, বিলস ছিল তো।
হ্যাঁ। Yes.
আচ্ছা,
এটা তো 25 দিয়েছো না? না,
এটা হলো অচেনা কুন্ডু একটা। সেম
না অচেনা কুন্ডু কেন আমাদের হলো না?
24 নম্বরটা আমাদেরটা হয়ে গেল। আমাদের অচেনা কুন্ডু একটা।
দেখো।
Yes, I've got the applicant. But appellant before your Lordship Milord was made a party in a writ petition being number Milord WPA 24026/2023.
Who are you?
But I am the respondent number 26 in a writ petition. That is WPA number
26.
Respondent number 26.
You must be having a name, na?
Yes, Dr. Achena Kundu.
Who is that? 26. Who is that?
Respondent number 26
Is
Dr. Achena Kundu. She was the reader of Jogesh Chandra Chaudhary Law College.
Now this appeal has been filed by whom?
This appeal has been filed by my client, respondent number 26.
You are Achena Kundu.
Dr. Achena Kundu.
Huh. Then
Milord, I am challenging the order dated 5th October 2023 and 6th October 2023, passed by the learned single judge. My grievance is, Milord, in this writ petition, although I was made a party as respondent number 26 within the area of the respondents, but without serving any notice, without serving any copy of the writ petitions upon this respondent number 26, an order has been passed by the learned single bench terminating my service on the ground that I am lacking of the requisite academic qualifications. I am not fit. I was not supposed to be appointed as a permanent teachers or reader of this college, law college. So I am agreed with this order, both the order dated 5th October 2023 and 6th October 2023, solely on the ground that without giving any opportunity of hearing, there is a clear case of violation of principle of natural justice. My service was terminated. Neither at the time of moving of the writ petitions, nor on the following day.
where is the 6th October order?
6th October order is I have annexed in memo. In memo of appeal, kindly see.
While he looks for the order, Malad, I should point out, Malad, that this appeal has not been served, as per my knowledge, either upon the GP or
First
the
tell us
LR.
it was which benches released this matter.
My lord, the court
My lord,
bench presided over Justice Show mentioned.
My brother was not
No,
there.
madam.
Huh?
Justice Sen.
Was any order passed on this matter by my brother? First ascertain that.
No, my lord, on 29th November 2023,
আমি জানি না।
this matter was released. Yes, madam, I have come with the order. Release order.
This was, we find তাহলে কি ওটা আগের ম্যাটার হয়েছে?
Malad, the last order sheet was of item number 26. Last order sheet, Malad, which Malad fell from your lordship for us to look at, Malad, was in item number 26.
MAT 2255. Oh, this is 26.
And this is the MAT 2184.
2184.
Yes.
And who is the appellant in 26?
But
Dr. Shunanda Goenka.
You are there. You have challenged which order again?
Oh, the other one. Well, that we have challenged your lordships. The writ petition was dismissed, but on a review application that has been again restored and to be heard for hearing. That order, the order passed on review application, we have questioned.
Oh, the writ petition was dismissed.
Then on a review application was moved by the
This writ petition has been restored.
The order of dismissal was recorded. Rather. So we have questioned that order passed on the review application.
Chronologically,
the initial order passed by the learned single judge was stayed.
Was stayed.
That is item number
no,
20.
by this honorable bench was set aside. By this honorable bench was pleased to set aside. My lord was pleased to set aside the order.
Set aside. We have not set aside.
Only the portions of the terminations. My lord passed an order. I have come with that order. My lord was pleased to set aside that portions of the order with regard to termination, and my lord directed the learned single judge to rehear with the liberty to exchange the evidence.
Right.
Yes.
Thereafter, the matter
was heard.
And
no, on the following day, or one or two after, on 9th October, as I can recollect, 9th October, my lord, the writ petition was dismissed. Since the writ petition was dismissed.
No. When was his lordship's first order?
5th October.
Yes,
5th
may I assist you?
I have annexed
5th October, your lordship.
First order, 5th October.
Oh, তাহলে how can we?
না, আমার writ petition, আমার brief দাও।
এটা আপনার brief না?
না।
এটা কার brief? খুবই কম বুঝতে পারছি।
Second order, 6th
তুমি আমাকে একটু ওই আগের ইয়েটার ওই অর্ডার শিটটা দাও তো, ওই আইটেম নাম্বার 25 24 টা একটু দাও তো। No, Mr. Sannal, first the dispute was you were terminated without any notice by one order. What was the date of that order?
5th October 2023.
By order of the learned
Single judge.
So against that you came up in appeal.
Before your lordships.
So we said that
your
that portion is
removal was set aside.
and you are
My lord,
beside
you
the matter.
directed the writ petitions to be heard on merit,
Now,
on
after
affidavit,
hearing, his lordship passed another order on 12th October.
12th October.
6th October confirm করলো। 6th October একটা order আছে।
কি confirm করছে?
Single judge।
No, there is no order of confirmation.
নিজেদের মধ্যে
No, my lord, I tell your lordships. Your lordships, 12th October, the order was passed by the learned single judge.
directing CBI, directing an inquiry.
No, did not directing inquiry. My lord, your lordships,
We have the order of
Order.
18th October before.
18th October.
That
Your
is
lordships,
our order.
our order.
Uh-huh.
No, that's Neil Basu. My lord, probably that's Neil Basu.
My lord, let me, with kind permissions, I'm seeking from Mr. Sarna.
No,
Mr. Nondi, he just tell us the facts now.
No, I tell your lordships.
So my matter, let me place the facts from my end. So, my lord,
We shall hear you. I am confusing it. First, one matter came, we passed the order that that portion of termination is set aside. The learned single judge will hear out the matter. Now, after that, his lordship passed another order.
My lord, another writ, my lord, there are two writ petitions.
Oh, acha.
One questioning, my lord, my appointment, approval, everything. Uff, ab bolte dao. And the another writ petition was, my lord, in regard to criminal proceedings initiated against me according to the writ petitioner, which was not being properly investigated by the police, whereas the FRT was, my lord, filed by the police. My lord, that writ petition was, my lord, your lordship, state the proceedings of that writ petition.
In that, Mr. Bandyopadhyay prayed for time for extension.
Exactly.
Oh. That was the FRT matter.
FRT.
Acha, then what is
The Neil Basu matter, where your lordships removed the portion of my removal ex parte, that again came up before the learned single judge immediately after your lordship's order was passed.
So that Neil Basu is not here. We disposed of the appeal.
No, Neil Basu, your lordship's 26, if I am not wrong.
Basu is 24.
24.
That is item 24, where lordship just extended the time.
That
Item
is
number
Sunanda.
20.
That is
Neil Sunanda
Both are
going
Sunanda.
from the Neil Basu order. There the writ petitioner is Neil Basu.
Oh, I see.
এটা Danis.
এটা দানিশ।
This is, my lord, Danis Faruqi. এটা হচ্ছে তো এই
Now,
criminal proceedings.
Danish
No,
Faruqi
no,
filed the writ petition challenging what?
Danis Faruqi removal. Neil Basu, your lordship's criminal proceedings.
Oh. Neil Basu criminal.
Criminal. That your lordship extended the time for filing affidavit and the interim order. Your lordship was pleased to stay the further proceedings of the writ petition. So for Danis Faruqi is concerned, your lordships.
Now there is one problem, Mr. Shanna. In MAT, because these matters needs to be heard together, na? Same college, same. This MAT, কোথায় গেল এই অর্ডারটা দেখালাম? In MAT 2255.
Yes, your lordship.
That is 26. My brother was sitting with Justice Bakchi when the matter was released.
Delisted, not released. Released question. Released, your lordship. I'm stand corrected. Released. My lord, I tell your lordships.
When it is released, whether my brother can hear this.
My lord, I tell your lordships, my lord, the facts remains. This is the personal ground of the Honorable Mr. Justice Bagchi.
Oh, we could have heard then. It's a joint order.
Order joint. Obviously, your lordships, order joint. But the reason, your lordships,
No, it is not that one of
that your lordships can leave.
If it was recorded that.
No, that I get your lordships point. I get your lordships.
So এটাকে we keep it after vacation.
No, my lord, kindly keep it on Monday, your lordships.
Why? What is the hurry?
There are some certain things to be placed before.
What things you will place? Review
Now,
application. Review application has been allowed. Writ petition has been restored.
Restored.
Affidavits directed.
The writ petition is restored.
Now the writ petition has been fixed on some Monday again.
But
Returnable on Monday.
But the order passed in that writ petition has been stayed by this court.
My lord, but your lordship directed the the honorable single judge to hear the parties, that is the appellant before your lordship at that point of time, and the other parties to be heard upon exchange of affidavits. My lord,
Now that
the affidavit has not been filed, my lord, as I understand, I do not know, because I am a co-respondent. It has not been served upon me, I do not know. But UGC, it appears, has filed an affidavit which says that
File an affidavit, UGC has
Served.
served an affidavit.
Right. Served upon other parties.
No, I am asking, suppose the parent order of his lordship, there is a stay.
No, only the part so far as Dr.
that's the
Shunanda
part.
Goenka's termination is concerned, and she used to officiate as the principal, and the special officer was discharged from his duties, who was appointed by the Honorable Single Judge.
Now, your lordships, this order was passed by your lordships. If I am not wrong, your lordships, this order was passed on 12th October. Writ petition. No, 12. Your lordship's order.
11th October.
11th October. Now, kindly take a stand. 11th October, your lordship's order was passed on appeal, arising out of the Neil Basu's matter. Done is better.
Done is better.
Done.
Yes.
Now, the very next day, writ petition came up for hearing in the list. On the very next day.
That is on 12th.
12th.
They mentioned.
Upon their
petition was dismissed.
This petition was dismissed. My lord, writ petition dismissed on the basis of your lordships. One of our allegation before your, my lord, in the appeal or that the writ petition itself should not be entertained because of the conduct of the writ petition. That ground was accepted on the 12th. Now, writ petitioner came up with a review application. Review application was on that there is certain error apparent on the face of the judgment.
Now then the 12th October order was recalled.
Recalled on review.
By an order dated
17th October.
17th October.
Now when the writ petition is recalled, what happens to our order?
My lord, your order, my lord,
Has
that's
lost its life with the dismissal of the writ petition.
I will be arguing all that, my lord. I will be arguing all this.
My lord, that all the interim orders subsisting in the writ petition were directed below to hold force as they were holding force on 12th. That is clarified in the order of restoration itself, which has been passed by his lordship.
So interim orders pertaining to those passed by his lordship.
And there were no other interim orders passed by your lordships because your lordships are pleased by order dated 11th.
We have disposed of the appeal.
Yes. So there was no interim order passed by your lordships in that, right?
So, my lord, I just request your lordships kindly, I will be placing because it's a very subtle point involved certain regard to the exercise of writ jurisdiction.
We are trying to ascertain how he will be prejudiced.
That's my point, your lordships. I get your lordships. My lord, that's the main point. Probably I have to meet before lordships in the hearing of the appeal also. Now, your lordships.
The last order, which is with me, my lord, passed in the passed by the honorable single bench, is to exchange affidavits.
এই দুটোকে মঙ্গলবার দিনকে লিস্টে রেখে দিও।
সোমবার দিন রিমুভ করে দেবে
25-26
My lord, your lordships, I just for your lordships, I do not know. Your lordships keeping it at 19.
Yes.
Yes. No, my lord,
I
get your lordships. I have been directed upon restoration of the writ petition again on file to file an affidavit. I take exception to that. Now I have not. Now 18 the matter will be taken up. I will be again removed. I have to come up again. Kindly visualize the situation. That's why we are, my lord, getting it. My lord, really
subject to what you people say, there is a review order recalling an order. Now upon recalling, the court has to hear it. If so his lordship desires, then there will be a direction for affidavit.
That hasn't passed.
Oh, that hasn't
passed.
Lordship passed that order, my lord.
Yes. Now after that it has
My lord, if he is agree, if Mr. Sannal says that he is prejudiced by the direction of filing affidavits, he has to prefer an SLP from your lordship division bench.
No, my lord, sorry. Don't take it so easy.
No, it will come on Monday.
Don't take it so easy, my lord, because I tell
your
you,
lordship directed affidavits to be filed. That also they do not want to file.
My lord, I was not required to file an affidavit because the learned single judge was satisfied with the conduct that he can't maintain the writ petition. That was my basic point. Now, that point again revived by the learned single judge on the review application that those documents were not with him. But the memo of appeal says this is error apparent of the face of the record. The learned single judge make out the ground, third case for the petitioner itself. So this is my point before. This is not a proper exercise of jurisdiction by the learned judge. Then I am asked to file an affidavit that my whole defense goes. Kindly visualize this. This is the situation I am facing before the learned single judge. But I'm sorry to point out certain things which is not so good before to argue before the court.
Mr. Sannal, you are anticipating something and
I am not anticipating something. If I go with an order, the appeal is pending before the learned single judge. Learned single judge says, no stay, let us proceed. All right, not everybody will say.
When your lordship had been pleased to stay the directions in the earlier round where Mr. Sanyal was moving the appeal, my lord, only two paragraphs I'll read, my lord. One says that the allegations have been leveled against the appellant in the affidavit filed on behalf of the state in the writ petition after the order passed on 5th October. The appellant should be given an opportunity to deal with the allegations leveled against her. Then, in the next page, your lordship directs that the learned single judge shall decide the writ petition finally after granting liberty to the parties, including the appellant, that is Mr. Sanyal's client, to file their respective affidavits. Now, their point of prejudice is that if the writ petition survives, I have to file an affidavit. The only point of the appellant is that in item number 26, somehow not to file the affidavit because they cannot disclose that they have the requisite qualification which state's committee has given a finding that they do not have requisite qualification. State,
all right.
And now UGC also.
All right.
Actually, the UGC, they do not have the requisite qualification at the time
Wait,
of
madam, we are not passing orders. We cannot hear the thing. It is Monday. Let us see, come back on Monday. What? You are laughing. I will
তোমারটাও করবে আমারটা তো করবে সোমবার করতে হবে আজকে করবে Well, all the matters are to 24, 25 and 26 both.
25 and 26, we keep it on that day.
25 is my matter. Let me place this appeal, my appeal.
No. Your appeal, what did you hear so long?
No, kindly.
My brother is there in 2255. It is relating to the same matter.
No.
So it will be better if we hear it together on the next date. When there will be another honorable judge sitting. We finished.
In the meantime, my learned friend's advocate may serve the appeal on the government pleader and the legal remembrance.
This is my individual service. We have served upon all.
We have served by email.
You don't serve, there is no scope for passing any interim order if you don't serve.
No, already served. I have served upon all the parties. I have served upon all the parties. That's why.
You said that you collected money.
That has been reversed. If I may say so with greatest of respect, Lord, the honorable judge on the matter being returned after the division bench's order was closed, after your lordship's order was closed, and after the matter was being heard, his lordship was persuaded to hold that I am not entitled to any relief because I have not completely enhanced according to his lordship. Because of the reason just now which has fallen from your lord. Then, I take out a written application. Placing on record documents that I was authorized to collect money and I was authorized to act, and that was accepted by the honorable single. And his lordship, on review, upon hearing, because his previous order, it was a span of 4-5 days. Now, when the revival of the initial order would mean revival of the
We understand. His prejudice is there, he says. So we will consider that prejudice. Exactly. We will hear him and finish it up. The problem is we cannot hear it today. We will hear it on Monday.
But kindly takes up my appeal at least because
on Monday.
today, Well, I have served upon all parties. Because I am also agree.
Your lordship, take it for this first matter.
Pardon?
আমি তো আসছি না।
Take it up as
আমার তো
first-
tomorrow আছে matter, single bench.
Latest.
The difficulty is because another writ petition I have filed, that writ petition will is listed tomorrow.
Voluntary retirement.
Sign matter.
ওইটাই ওটা কালকে ফিক্স আছে না, কোর্ট আমাকে বলেছে তুমি প্রসিড করো।
ছেড়ে দাও, ইডি অ্যারেস্ট করে দেবে গোয়েঙ্কাকে, তারপর আমরা তোমাদের একটা সিগনেচার করে দেবো। আমি বলছি তো, ছেড়ে দাও।
May I submit evidence or I'll keep it.
Monday.
Keep it, bring it on Monday. We shall take it on record on Monday. Yes, take it.
বলছি তো তোমার কোনো চিন্তা নেই।
ঠিক আছে, টেনশন হচ্ছে মুখ খেলে না।
বলে দাও এখন যা আছে রাখছো, তারপর
আমাকে সার্ভিস করেনি।
এদের রয়েছে সার্ভিস করেছে, তুমি কার হয়ে বলো?
আমি রিট পিটিশনার হয়ে, আমাকে সার্ভিস করেনি, আমাকে মেলে দিয়েছে, আমাকে হার্ড কপি দেয়।
হার্ড কপি দেয়, মেলে সার্ভিস,
আমাকে একটা হার্ড কপি,
সার্ভিস হ্যাজ বিন এফেক্টেড।
আমাকে যে হার্ড কপি দেয়।
আমি পড়ে দিচ্ছি এখন।
लीडर काइंड ऑफ होता है
Combined with the Vishwarup Bhattacharya. Vishwarup Bhattacharya. Yes, which is your matter, Miss Alam?
Lordship, the matter, item 58 combined list, Lordship.
That is a tribunal hearing. Hearing or motion?
Actually, it's a motion. It's hearing, but no, anyway, I give it to your Lordship. Doesn't matter.
So who is your other side?
Well, I am for that.
You're there. তাহলে দাও আটান। What is the matter about?
Well, this is the old matter of 1992. My lord, the matter was transferred, my lord, in the year of 2002 before the Central Administrative Tribunal. My lord, seeing that this is a civil post and the matter should be referred to the, my lord, the Central Administrative Tribunal. Now, my lord, on 2002, 2007 to, my lord, 2002 to 2007, the matter was taken up for hearing with the Central Administrative Tribunal. Now, in 2007, the Central Administrative Tribunal has hold that this matter is related to the civil post. It should be referred to the, my lord, the High Court. Now, in
2002 notification RPF.
And 2007, the order was passed, and I have challenged the order of that order, whereby the tribunal hold that the matter related to the civil post, and so the matter referred to the High Court.
Because of the
Lordship,
notification.
he was working under the RPF. RPF is not a notified organization. Therefore, RPF matters come before this court only.
Then why you're wasting your time
That
here?
is why
File a
he
writ
let him
petition.
file.
The writ petition is still pending, my lord.
Petitioner is also no more.
The writ petition is still pending, and which is
When the initial writ petition was filed, it was reverted back since it is a civil post to be heard by the tribunal. Now, in the meantime, notification has not been issued. So they have proceeded on this basis that 14(2) coverage is not there. So go to High Court again.
the order of
Now that old writ petition, which was transferred application, which was sent, that has been dismissed now.
No, that has been pending. My lord, the CO, my lord, the earlier writ petition being number CO number 153 of 1992, that is also, my lord, before your lordship, my lord, in the list. But because, my lord, those matter, the writ petition along with this matter, my analogy taken up for hearing. Though, my lord, this
Who said that?
my lord, there is an order to that extent, my lord, by my lord Justice, my lord.
I don't know which is the order.
The order, my lord,
No, let us understand. You are an RPF employee.
Yes.
I am the, my lord, the RPF employee.
So what happened to you? Why did
I
you
was
come?
terminated from service.
Very good. You
I am challenging
terminated
that
in
order
which
of
year? Wait, terminated in which year?
1989, my lord.
1986. Removed. 1986.
96, 2006, 2016.
Maybe 40 years, 38 years.
Meantime, my lord, the employee died, my lord, substitute
there.
was done.
So very good. The tribunal, when where is the order transferring the matter to the tribunal?
That is the, my lord.
But Miss Alam, if tribunal passes that order, then it becomes violative of the order passed by the High Court.
Actually, what has happened, I mean, we don't find it, but this was why it was transferred, we really don't. I mean,
that order
is not there. Why it was transferred from the High Court to the tribunal, I don't know.
Show us that order,
That order,
Mr.
my
My lord, that is with, my lord,
No,
that is on
that-
2002 order, my lord.
Whatever it is, but I don't find that the papers that are
Your
with
lordship
me are
kindly
not
come to
there.
page 48 of my center, page 48. This is the order of the tribunal. Here there is mention.
We are asking one question, you are giving another answer. We are asking a simple question. Do you have the order by which the transfer, the application was sent to the tribunal?
I have no order, my lord, but in this order, my lord, there is a mention to that extent.
That is.
It's just one line. This application
Just
was
one line.
originally filed before the Honorable High Court. Is there any direction from the High Court?
Yes, my lord.
This is no direction.
The matter was
But
transferred.
Lordship, it was transferred. Somehow it was transferred. I mean,
being
how?
TA number, my lord, so my lord is
So that-
remembered as a TA number,
Yes,
11
that
of
is
2000.
something which my learned friend has to.
No, Miss Alam, we are asking, once an application has been transferred, can the tribunal reject it and send it back to High Court?
Lordship, that is the question. I mean, how that transfer has happened, Lordship. Because after the if lock, stock and barrel service matters were transferred at that time, that this is right at the beginning. Therefore,
was a general draft.
Yes, I mean, what
Nothing was decided.
No, that is the thing. So it is ultimately when they applied their minds to the matter in the last impugned order that they saw that it was
Where
not.
is then why didn't you point this out to the previous
Lordship,
courts?
because what I find is
Immediately adjourned,
2005, yes, it is very unfortunate. But this is the only way back in 2007 when the final hearing that was taken up.
Was the order impugned?
Page 54.
54. That is simple. He's not got into the merits at all.
Nothing on the merits.
Nothing on merits.
The writ petition was originally filed before the Honorable High Court.
So after this is the only challenge is this one?
The only challenge is this one.
The writ petition is 2007.
Because
so what will you get in this?
Ideally, they should file afresh.
The matter is still pending on 2007.
Merit, the tribunal has not decided on merit.
No,
it is only to the extent of jurisdiction.
Which matter is pending? You are saying?
The original matter, when the matter was referred to the
what is the number of
being CO number 11153 of 1992.
That matter has merged with this order because on the CO the TA number was placed and the TA has been sent again to the High Court.
And
matter was heard on and while recording order is
been transferred to the
treated
High
under RPF Act. Applicant does not appear to be a civilian railway employee and therefore tribunal has no jurisdiction to entertain as RPF personnel are outside the purview of the Administrative Act. In this context, decision of Guwahati High Court may be referred to. Now, challenging this order of 2007, you came here.
Yes, ma'am.
And you are continuing since then.
That is 2007 to 2023, ma'am.
You should have filed a fresh writ petition.
By this time, you would have filed a fresh
He is no more, Lordship.
When the
He
matter was
also passed away.
remanded before this Honorable Tribunal by virtue of this order, impugned order.
This file will not come before us also.
Yes, Malad, this is, Malad, I think, Malad, the file.
It is going to go to the single bench.
Malad, this file is attached with the Malad.
Yes. You got changed into transfer application.
It is going to.
That has been sent back to the High Court.
Malad, the.
What is the wrong with this order? Tell us.
Today, my lord, subject to your correction, my lord, the main file, my lord, the CO is 193, attached with this file. My lord, let the, my lord, the
attached with this file.
This file, my lord, because my lord, there is a several order passed by my lord Justice, my lord Ashok Dasudhikari.
You are not concerned. If there are favorable or disfavorable order, you should trace out the file. It was incumbent upon you to check up the file.
I have checked up the file, my lord, that is with.
Where is it? Where is the CO file?
CO file is, my lord, with that file, my lord. May I just.
Yeah, it's there.
Listen one thing, your transfer application has been disposed of by the tribunal, matter has been sent back to us in
My lord.
2007.
My lord.
Good, bad, indifferent matter could not be heard.
My lord.
So the issue of termination has to be now decided by a competent authority.
My lord.
So we will grant you leave to file a fresh writ petition,
that
and
is
we
the
will
best
direct that
solution.
the same shall be heard out on merits. No limitation will arise. Finish.
Because he is also, I mean, the petitioner is also, heirs have been substituted, I feel.
Heirs have been
Yes,
substituted.
yes, so
Now you are appearing for all.
yes, Lordship.
Most probably you are appearing.
For
Let
the
us
role,
see.
yes. I don't think there are any private.
Yes.
No.
Private claim.
Termination will be challenged.
Lordship for all.
Are the petitioners still there? The substituted applicants are here. You know that?
Yes, yes, my lord.
All of them. Mao বেঁচে আছে?
Mao
They
is-
will Mao
Mao
will
is
come and record. Mao.
Or did we keep it in the supplementary
Yes,
list on a
Lordship.
returnable date?
Lordship, Lordship.
In the meantime, you check up the file and make a list of dates. What are the orders we can go in?
Lordship.
Check up the file and come.
Lord.
আসো কবে রাখবো বলো তো? In the meantime, you avail instruction.
Whether they are alive or not.
What instruction they will give? Whether they are desirous of continuing with this or not.
They are pursuing the matter, my lord.
You are terminated on what ground? Unauthorized absence?
Unauthorized absent.
Only unauthorized?
Only unauthorized absent. And no order, no termination order was served upon him. We prepared an appeal. Appeal was rejected without hearing us, my lord. That was also count in the writ petition.
Miss Alam, have you checked?
I'll just see if they can retrieve anything from
because we are pondering on the issue as to whether we are exercising writ jurisdiction. We can go into the validity of the termination order also.
Lordship, as of in this WPCT, it is only limited to the order impugned, which is sending it back. He has
Yes.
not entered into the merits at all.
Right, we will decide the matter.
And therefore, if he is given the liberty to file a fresh writ petition, maybe
Miss Alam, you
I'll get the records. I'll ask for them, whatever they
Miss
have.
Alam, you get yourself ready
Yes,
on the
Lordship.
merits of the matter. Because
On the
today,
okay,
if we
Lordship.
ask them
After
to
all
file
these years, I understand.
40
Lordship.
years.
Yes, Lordship.
Any
I'll
forum
ask,
will
I'll
say
ask
that
my
why did
client
you
to
do this?
produce whatever so that it can be finished up here. only.
And if required, you prepare a short affidavit to that effect. If required,
If required, let me see what I get
or you
also
get a
after all this.
compilation of the document.
Lordship,
Because
I'll
these
just
are very old.
very old doc. That is why let's see what I get also.
Hard. Are the learned advocates appearing for the respective parties? Where is the order of transfer? You don't know.
No, there is no order of transfer to that.
It's
Because
just
I
a
think
TA
that there is
number
no-
from where we get.
Only there is a TA number.
দেখো তো ওই সি এর ফাইলটায় লাস্ট অর্ডারটা কি আছে? সি ওর ফাইলটায় কোনো অর্ডার আছে?
Lordship, could I take your Lordship's leave?
Yes. No, we are
But we-
fixing it on a date in January.
Lordship.
Let your junior be here.
Yes, leave.
দেখে নো ও আসলে ওকে ফাইলের একটা ইন্সপেকশন দিয়ে দিই। Are the learned advocates appearing for the respective parties? This the matter for further consideration in the daily supplementary list of this court on 22nd January.
22nd.
Stop. এটা তো 20 আমাদের এইখানে ছুটি 23rd কি আছে? কোনটা? না এটা সাপ্লিতে দেবে তো সেই জন্য। এটা তো ওখান থেকে তুলে এনে সাপ্লিতে দেবে। You in the meantime, you check up the records and Miss Alam,
I'll
please get the records to them.
Lordship, Lordship, may I,